Special weekly list item number 4. Special weekly item 5. Special weekly list item number 6.
Your Lordship, in item number 2 to 6, on behalf of opposite party, name of Mr. A.P. Das may be kindly noted.
Special weekly list item number 7. Special weekly list item number 8. Special weekly item 9.
Need, please, my lords. Lordships, the issue involved here is enhancement of turnover, my lords. My lords, the petitioner has undergone enhancement. Petitioner undergone. My lords, may kindly have a glance at page 49 of the brief, my lords. My lords, this is the
Mr. Ansel, what is the issue?
Lordships,
Involvement is 65,000.
yes, my lords, enhancement of turnover of the
What's the tax effect, sir?
65,000, my lords.
That's the question that you're framing. You're urging this question to be considered page 19.
My lords, the issue involved here is whether in the facts and circumstances of the case tribunal was justified to reject the petitioner's claims of sales tax exemption on the sale of finished products produced from the expansion undertaken on his existing small-scale industrial unit by holding the petitioner to be entitled to sales tax exemption under entry with effect from 1/12/89, my lords. My lords, may kindly have a glance at the letter at annexure 9 at page 55, my lords. My lords, that is the letter from the
Your Lordship,
DGIC, my lords.
Mike, I think, mute, Your Lordship. My Lord.
What's the tax effect?
My lords, the tax rate is 65,000.
So why did we interfere now?
My lord,
Already
but,
20 years old.
My lords, may
We'll leave
kindly
the
have a
question
glance
open
at
for consideration some other appropriate case. The tax effect being insubstantial, the court is not inclined to interfere. Leaving the question open for consideration some other appropriate case, the petition is disposed of.
Special weekly list item number 10.
20,820.
Yeah, anyway, none appears dismissal or prosecution.
Special weekly item 11.
None appears dismissal or prosecution.
Item number 12.
$28,800.
Or none appears dismissal or prosecution.
Item number 13.
No instructions, please.
No instructions, dismissal or prosecution.
Special weekly item 14.
None appears dismissal or prosecution.
Special weekly list item number 15.
None appears dismissal or prosecution.
Special weekly list item number 16.
No instructions, perhaps.
No instructions, dismissal or prosecution.
Special weekly list item number 17.
Made, please, my lords. Lordships,
39,000.
no, my lords, that is 51,000, my lords.
What about that was 69? This is 51, sir.
That assessing officer has allowed the refund 12,692.
But there is no,
ACST has allowed 51,732.
but there is
So
no new
if it
facts,
is
my lords.
deducted from that ACST, then it will be 32,300.
My lords, but there is no new facts that has been discovered before opening of this case, my lords.
The tax effect being insubstantial, the court is not right. Frame the questions at this stage.
Deeply, please.
Leaving question open for consideration some other appropriate case.
Deeply, please.
Special weekly list item 18.
Your Lordship, 18 is to be rejected
All right.
on Your Lordship has passed that meter rent, Your Lordship, high charges of meter.
I see.
So it is against the revenue.
In view of the decision dated 10th April 2019 of this court in STREV 68 of 2004. Bracket. Executive Engineer Ganjam North Electrical Division on the state of Orissa. The present revision petition is disposed of. Dismissed and is dismissed.
Special weekly list item 19.
No instructions, please.
No instructions.
Special weekly list item number 20.
28.
Item number 20, special weekly list.
And none appears to sit from prosecution.
Special weekly list item number 21.
May I please, your lordship?
Yes.
The question of law has been admitted by your lordship by order dated 21/4/2008, my lordship. I may be permitted to place it.
Yeah.
Whether in the facts and the circumstances of the case, the tribunal was justified in confirming the decision of the assistant commissioner refusing to give adjustment of the sum of rupees 83,257 paid by the petitioner at the check gate during the year 1989-90 as against the tax demand for the year 1991 by not following.
What's the tax effect here?
Well, it's 83,257. Well, the only dispute is that I have paid the tax at the check gates. It is not disputed that I have not paid. I sought an adjustment of tax for the subsequent year. That has not been given. The case is very simple. I pray that against my demand, that adjustment may be the tax paid. And
What does the tribunal say?
Tribunal just endorsed the view of the assistant commissioner.
Let's read the relevant portion. Para 2. Start from para 2.
Your Lordship,
Maharaj, kindly see page.
para 6 last portion. And in tribunal is stated.
Last portion, my lords, regarding the disallowance of the claim of exemption and the adjustment of the tax paid at the check gate, the learned ACST has given proper reasons for his conclusions on the matter, and we find no justifications to interfere, my lords. The observation of Assistant Commissioner is at page 17. 17, my lords.
17.
Yes, ma'am.
Yes.
As the first paragraph, 7 line regarding the claim of adjustment. Regarding the claim of adjustment of the tax paid. First paragraph. Above 6.
Yes.
Regarding the claim of adjustment of the tax paid at check gate for the previous period, it may be observed that no such adjustment is possible for the payment made during the previous year against the admitted tax payable for the current financial year. My humble submission, my lords, there is no such prohibition under the Act that for the previous year, if tax has been paid, for the subsequent year, it cannot be adjusted. I had purchased goods in the year 89-90, my lords, and that I have sold in the year 1991 subsequently. Therefore, I sought an adjustment for the subsequent year, the tax paid at the check gate. My only case is that.
Yes, sir.
Your Lordship, it is the previous year payment, and the payment has been made due to non-disclosure or there is some error in the way bill so far as that is tax and penalty. So in the subsequent year sale, what is the tax liability? The petitioner wants to adjust that amount, Your Lordship. That amount may not be adjusted, Your Lordship, because that is the previous year payment.
No, but that was an excess payment, correct?
Your Lordship, that might be excess payment, but that payment was for the previous year,
But
not for this year.
when suppose a person is the excess payment can't be
No,
adjusted.
Your Lordship, suppose in the income tax, Your Lordship, I have paid some
So
more.
you have to ask for refund of that year,
That
again
is-
pay for this year.
Your Lordship. Exactly, Your Lordship. So that cannot be adjusted because there is no provision for adjustment of the previous year's excess payment.
So you should have returned them.
Your Lordship, if at all he has to file refund application, and as per law, Your Lordship, if at all.
My lords, I may correct my friend's submission. Under the Income Tax Act also, there is a provision that if there is a demand and refund it is flowing from some assessment year.
No, so there is a determination of that refund. No? You have to first determine that refund. You have to make an application. The authority will say, yes, this is the refund admissible. Then you can ask for it.
He keeps just merely just.
That is the same thing also so far as OST or VAT Act.
Proviso to my lords, the Rule 36 prescribes for adjustment of tax. My lords,
No, this is the previous year.
previous amount. There is no such provision. The proviso doesn't say that for the same year only the adjustment can be made.
Yeah. Because each year is a separate year. The whole assessment takes place. Then you determine what is excess paid, refund. That's how it works.
Well, this judgment passed by your lordship may kindly receive.
So let's say on your part, you should have applied for that refund that you have not done.
This is all pertaining to the same year, even 36.
Well, it's para 4, second page. Well, it's, the proviso of Rule 36 has been quoted thereafter. The lordship has held. Apart from this proviso, we do not find any other provision for adjustment of tax paid by the dealer at places other than the check gate or barrier, as in the present case. But in view of the fact that under the scheme of the Act, multi-point taxation is not intended, we feel inclined to hold that the dealer should be entitled to claim.
We're talking of previous year. The same year is different, sir.
Subsequently, it has been mentioned, madam. I may be permitted to place matters. Thereafter, we feel inclined to hold that the dealer should be entitled to claim adjustment of taxes which are paid for the same commodities by him at places other than the check gate in similar manner. In this case, we find the dealer has paid the taxes to different sales tax officer after obtaining receipt in proof of the payments. But in subsequent assessment proceeding, these payments were disallowed on the sole ground that they were
Correct.
There was
subsequent meaning not the next year. Subsequent here means assessment takes place after these payments are made. That's what it means. The word subsequent means that.
Subsequent assessment proceedings.
No. Subsequent means the assessment took place after these payments were made. So those are subsequent assessment proceedings.
This pertains to 8990 minors. If I claim the refund,
that's all. Then better leave it, sir. We'll leave the question of law open if you're so inclined. Otherwise, you answer it against the assessor. What do you want?
My lords may pass an order.
All right. The following question was framed by this court by its order dated 21st April 2008 for consideration while admitting the present revision petition. Please take the question from page 5, italics portion. Paragraph. It is a case of the SSC that since it had paid rupees 83,257 at the check gates as tax during the earlier year, that is 1989-90, such payment must be adjusted against the tax payable for the current year, that is 1990-91. Full stop. Concept of the petitioner relies on the last proviso to section 36 of the Orissa Sales Tax Act Rule 36 of the Orissa Sales Tax Rules 1947. And also the decision of this court in Kshatriya Trading Company with the state of Orissa, 1987-67 STC 193 bracket Orissa. Paragraph. The court finds that the relevant passage of the above decision, which talks of payment made at the check gate to be adjusted against the payment which is owed pursuant to an assessment, is in the context of payments of the same year and not an earlier year. Full stop. In other words, as rightly observed by the ACST in the present case, there is no provision that permits tax paid for a previous year to be adjusted in the current year, in the earlier year to be adjusted for the current year. Full stop. Obviously, if any excess payment has been made in the earlier year, it will be open to the SSC to claim refund of such excess payment. Full stop. Here, obviously, there is no such claim for refund, which has been determined to be payable to the SSC. Full stop. Even if the refund amount had already been determined, it would have been possible to consider whether it can be adjusted against the current liability. Full stop. Here, since no such refund has in fact been determined, had been applied for or determined, that question does not arise. Paragraph. Consequently, the question framed is answered against the SSC and in favor of the department. The revision petition is dismissed.
Special weekly
Item 20, Malats, we just need a passover, Malats. Item 20. 20, we just need a passover. Mr. Sao is on his legs. Malats.
All right.
Deeply rest.
Special weekly item 22.
No, please dismiss an opposition.
Special weekly item number 23.
Item 23, we don't have any instruction.
No instructions.
Special utility item 24.
Malone, we don't have any instructions.
No instructions disposed of. All right.
Well, I am appearing for the bank, my lord.
All right.
Special utility item number 25.
25, my lord. I request my lord to take up the second matter.
All right.
29461.
Right.
I filed a date chart, my lord, in that case. Whether the latest question in this matter is the inter se seniority between two set of employees.
Right.
May be permitted.
Field cartographer.
My lord.
Field cartographers, estimators, grade one draftsmen. All right.
Yes, Mr. Whether the petitioners in this writ application were recruited by the opposite party number.
How many of them are still in service?
My lord.
Are they in service? How many of them are in service?
Around 6 of them have retired. Your lordship may kindly see the order dated 18/4/2022.
8-4.
18/4/2022. On that day, I had submitted the persons who have retired and some persons who have also expired. 2 persons have expired. The petitioner number 1.
2, 3, 7, and 8.
Yes, my lord. 1 has retired.
That's all right.
4
So
has.
you are pursuing it for 2, 3, 5, 7, 8.
Yes, my lord.
All right. Tell us.
The petitioner in this writ application was recruited by the opposite party number 3 as junior engineers on temporary basis to officiate against the various force of field cartographer, SAE estimator, grade 1 draftsman, and return was allowed to continue as such by the same are challenging the order passed in original application 650/99, in which it was directed the official opposite parties to place the opposite party number 4 over the petitioner. Herein, although the fact remains that the opposite party number 4 was appointed in 1985, wherein the petitioner we appointed in 1983.
No. So was he appointed as a regular employee or a temporary employee?
Ad hoc employee, my lord.
Right.
My lord. I was appointed, my lord, in 23/9/83 and 3/12/83 on ad hoc basis as junior engineer, my lord. In 80 and on 6/5/85, the petitioners who were appointed on ad hoc basis were allowed to continue until further orders. 25/3/1989.
You're not given the date on which opposite party number 4 is appointed.
1985, my lord.
How come that you skipped in your list of dates? That's the most crucial fact. You've skipped it in the list of dates.
I'll show you from the
That's the only fact on which the whole case is based, correct?
in 85, my lord.
That you've left out. Very good.
25/3/1980.
What is the order? What is the date, sir? Show us the order appointing opposite party number 4. Mr. Mudili, you must be having it. Was he appointed on a regular basis, ad hoc basis? His case is that opposite party number 4 is appointed subsequent to these petitioners, and therefore he cannot be senior to
It's a
them.
temporary basis. Right?
My lord.
The word is temporary basis. There is no word like ad hoc.
My lord, annexure 1 temporarily.
Temporary.
The
Temporary.
following outsiders are appointed temporarily on ad hoc basis. Page 17. my lord.
All right.
Okay.
No. What's the order appointing opposite party number 4?
That is not in the record.
That's the main thing, sir. You're claiming
You are
that
also
you're
lying that-
senior to opposite party number 4. You're saying he also was appointed only on temporary basis.
No, I'm not saying that they were not appointed on temporary basis. They were appointed in 85.
On what basis?
The question
Basis. What is the basis? Appointment basis. Is it temporary?
that is not on records, my lord.
No. How are you making out your case? You're claiming parity
Yes.
as far as opposite party number 4 is concerned. You're saying that I was senior to him. Therefore, I must be shown senior to him the seniority list. That's the case.
Yes, my lord.
That you have not.
First, that's the whole basis of the case you're not establishing. It's not in your list of dates, nowhere.
That's the main document that would have helped you. On what basis?
I'll then
claim
look
parity?
for it and get back to my lord.
No. Not for getting back. What did the OAT do? Let's read the Orissa Administrative Tribunal orders. That might tell us something. Annexure C4. No. C4 is something else. Earlier OAT. This section. Where is the impugned order of the OAT?
Page 32, my lord. Annexure 7.
82 2011. Yeah, let's see this.
Relevant portion is at page 41, paragraph 6.
Yes. Read the whole para 6. sir.
Admittedly, the 9 private respondents in OAS were appointed as junior engineers on ad hoc basis by the Director of Soil Conservation, Orissa Cuttack, between September 82-84. As per the Agriculture Director of Agriculture and Food Production, Orissa, dated 11/2/99, it is already been decided that the common recruitment of junior engineers will be held in future. Deviating from this decision, that Director of Soil Conservation, Orissa, had made ad hoc appointments of few diploma holder junior engineers, which included the 9 private respondents. It has also been averred by the respondent that these junior engineers ad hoc appointment has been extended from time to time. Final order in this regard to the further continuance on ad hoc basis is in order number 627 dated 6585. No order regarding the regulation has been produced by the respondents, even if in their affidavit filed by 27/10/2010. It will thus
Been refused. The basis on which relief is refused is that they were regularly appointed, you were ad hoc. That's the whole point in the case, sir.
I know.
You can't complain, you can't claim seniority over regularly appointed people without being regularized yourself.
Because, my lord, my contention is if they were appointed in 83.
Regular basis.
I
You're
understand,
forgetting
my
the
lord.
basis. This is the whole problem.
I understand.
We've been asking for the last 20 minutes only this. We've been asking you repeatedly, show us the order, because you're claiming that opposite party number 4 was also appointed on an ad hoc basis. That is your claim.
Yes, my lord.
Where is the document to show they were appointed on ad hoc basis?
My lord, what happened in this case was
But the tribunal order is slightly different.
Yeah,
Then
my lord, there was
you
this
have to
order.
show without that document.
That
how
is
can
what,
you-
my lord, if my
You
lord,
are relying on something and we don't have document.
tribunal has come to a definite conclusion in way back in 1996, stating that our names were not included in the gradation list. I approached the tribunal. Tribunal said why this person's name were not included in the gradation list. A committee was formed. And they said that no, this person's name has to be included in the gradation list. And that thereafter, the opposite party number 4 approached the tribunal. Tribunal rejected their claim, and then I was given seniority over them.
Everything is in our air. So what
are your grievance then? If you are given seniority over them,
Then again, the opposite party number 4, he approached the tribunal, and then tribunal passed an order against me.
then what happened to that order? This is a petition by him or you?
By me. I was the opposite party in the tribunal, my lord.
No.
Petitioners
This
were the
impugned order
respondents.
is you are the opposite party.
Yes, my lord. I was the respondents in the tribunal. My lord, if my lord may kindly come to the date chart, I've given the brief how things have come to this point, my lord.
No. The point is, what question we are asking is not there in that date chart. Everything else is there. So that's the problem. You're not able to show your dates of regularization. You're not able to show that the other side was also appointed ad hoc. The tribunal has gone on the basis they were appointed regular.
It seems that the other side is on regular appointing. They are regular appointing. It seems the other side is regular appointing. If one can read this tribunal order, which you have not been able to show.
And all through from 1986 till 2019, my lord, I have been shown senior to them.
The merely being shown does not create any right, sir.
You show that.
In the gradation list,
you
my
have to
lord.
compare oranges with oranges, not apples with oranges. They were regularly appointed, you were ad hoc.
I'll try to collect with the appointment order of.
No. We're not adjourning all this. This is a 2011 matter. We're not adjourning like this. This is a final hearing.
Then may I place the date chart again, my lord?
Or date chart doesn't reflect anything unless you show the order from the date chart. You are not getting anything. Date chart is created by you.
And this you should have gone and produced it before the tribunal.
Your Lordship, can see page 36, paragraph 4.
Yes.
At bottom, the launch counsel. But
That's right. Who are regular recruitees. This
Yes.
is a very obvious. Yeah. This would be the first ground. Challenge the present petition.
My lord, may kindly come to page 38 for 1 minute.
Yes.
The stand of the government, my lord.
Yes.
Para 5, my lord.
Yes.
The learned government advocate narrated the background on which the names of these 9 recruitees by respondent number 3 were included in the gradation list of 14/11/96. They were included taking into account the date of joining as junior engineers. Since these 9 junior engineers had joined much earlier than the 2 applicants, there has been downgradation of the applicants in the gradation list. Thus, the claim of the applicants to be senior to the respondent number 4 to 12 is not tenable, and the gradation list of dated 14/11/96 is valid. This was
Maybe the government stands, sir, because that before the OET, they had to
because
defend
the
their own
interest seniority
action.
between these 2 persons
Correct.
were not.
Which is
They-
why they went, sir, because of this kind of placing you above them in the gradation list. They went to the tribunal.
I went to the tribunal first because my name
Sir,
was
this
not.
order is passed in in a petition filed by them.
Yes,
This
my,
order which you are reading.
yes, my lord.
Why
Okay.
did they go to the tribunal? Because of this stand of the government. That's why they went to the tribunal. You see, the challenge of the present petition to an order dated 18 February 2011 passed by the Orissa Administrative Tribunal, allowing OA numbers 650 of 1999 and 720 of 2000 filed by the contesting private opposite parties who had approached the tribunal challenging a gradation list circulated by the Office of the Director of Agriculture and Food Production on 14/11/1996, showing the present petitioners senior to them. Full stop. The case of the private opposite parties was that the present petitioners had been appointed as junior engineers in the Soil Conservation Office on temporary ad hoc basis, whereas the private opposite parties were appointed as on regular basis, and therefore the present petitioners could not have been shown senior to them in the gradation list. Paragraph. The impugned order of the OIT has proceeded on the basis that with the present petitioners not being regularly appointed GEs, in the absence of any regularization from the date of their initial appointment, they could not claim seniority over the regularly appointed private opposite parties. Paragraph. Counsel for the petitioners was unable to show that the opposite party, private opposite parties were also appointed only on a temporary ad hoc basis as the present petitioners. Full stop. On the contrary, the impugned order reflects the submission, at least at two places, that the private opposite parties were regularly appointed. If that is a factual position, then no fault can be found. The tribunal negating the plea of the present petitioners and allowing the plea of the private opposite parties that in the gradation list, they should be shown senior to the present petitioners. Paragraph. Counsel of the petitioners sought to refer to the stand of the state government as reflected in para 5 of the impugned order, supporting the stand of the present petitioners. Paragraph. The need for the private opposite parties to approach the OAT was precisely because of the above stand of the government in seeking to defend the gradation list issued by it. Full stop. Merely being shown senior in a gradation list would not sanctify the temporary appointments of the present petitioners or convert those appointments into regular appointments. Full stop. Therefore, the claim of the present petitioners only on the basis of the gradation list is not sustainable in law. Paragraph. For the aforementioned reasons, the court finds having been committed by the tribunal in allowing the applications filed by the private opposite parties. The petition is
Special legal list item number 26.
Obliged, my lord.
Item number 26, I am appearing for OSEPA, opposite party number 2.
Item 26 minutes. These are two analogous appeals minutes. I have received the file. I undertake to file the VNAMA today in the court minutes. But if your lordship permits, I'll place the matter.
Yes.
My lord,
Permit you, place the matter.
my lord, in this case, I am appearing for the opinion number 8. My learned friend filed a additional affidavit before this honorable court. That copy has not been solved.
Maybe, sir, for us it is not a problem.
So
We carry on with the appeal, sir.
I pray your lordship, kindly taken up after lunch.
No.
After lunch, my lord.
We'll just pass it over if you're so keen. We can't tell you after lunch, before lunch and all that. He'll pass it over. Or whenever it is called out, he'll be ready, sir. All right.
Obliged.
Item number 27.
27, the second sub-item onwards, the matter involves non-anchoring of the vessel at the Paradip port. Now the matter has, cargo has been unloaded and sold out. So, sir, virtually nothing remains. 7 except my demurrage matter. Your Lordship may dispose of the writ applications granting liberty to pursue my remedy with regard to demurrages in appropriate.
Counsel the petitioner says that in subsequent developments, the petitions could be disposed of as infructuous, granting liberty to the petitioner to approach the opposite parties as regards the demurrage. Consequently, the petitions are disposed of with liberty to the petitioner to approach the trust, Paradip Port Trust, as regards the demurrage charges. Right. The contempt petition is also disposed of.
Yes. May appearance may keep in record.
Yes.
I'm appearing to number 4.
Your Lordship, name of Mr. S.K. Padi on behalf of Paradip Port Trust may be kindly noted.
All right. All matters are over.
Subitem number 2, your lordship, and subitem number 6 on behalf of Mrs. Pamela for the petitioner.
All right.
All issues are same.
Special legal list item 28.
Your lordship may kindly permit me to move this application on behalf of Mr. Ghosh. My lord, here, a petition under section 22 of the Minimum Wages Act was filed before the opposite party number 1. The allegation is, your lordship will see annexure 1, at page 8. The allegation is that I am a service provider, had engaged some workers where the minimum wages was not paid out as per the notification under annexure 1. When the assessment, they filed the application under annexure 1 at page 8, my lord, your lordship will see at page 8, paragraph 2, the applicant estimates the value of the relief sought for the employees on each account as per rupees such and such as less payment. The applicant therefore prays that a direction may be issued under section 22 of the Act for payment of difference between the wages payable under the Minimum Wages Act and the wages actually paid, the payment of compensation such and such. My lord, immediately I paid the money under annexure 4, your lordship may kindly see. All the 59 workers, 56 workers, my lord, I have paid, they have signature, this document was filed before the authority. Now your lordship may kindly turn to the impugned order. My lord will see at page 26. The paragraph 6. The opponent submitted a payment sheet that payment of differential wages have been paid to all the workers. The payment sheet was handed over to the applicant for verification of payment by contacting concerned workers. The applicant verified payment by contacting 15 workers out of 54. The available workers have confirmed that they have received the differential of wages. The applicant has further confirmed that on inquiry, workmen present stated that they all have received the differential payment on same day. The opposite party made a prayer to close the case as they have made payment to all workmen. The opposite party did not produce the rest workers. But they were the inquiring officer, they will find out. And your lordship knows which is the security of the mines, shift-wise they work. The opposite party did not produce rest workers for which he could not verify payment position. The opposite party further submitted rest workers have left the site and their whereabouts are not known. As there was violation of provision of such and such, due to short payment, employer was paying less than the minimum wages declared by the government of India. The applicant prayed to award maximum compensation as per law. Then your lordship may kindly turn to page 27. The verification report speaks that 15 workmen interrogated have received excess amount than that was claimed by the applicant. Even the workmen interrogated confirmed to have received more than the amount said to have paid by the opponent. Even if there is some fallacy, it is accepted that the workmen interrogated have received the differential payment. In spite of this, he directs to payment of such and such money. But Lord, I have already paid the money. And this fact has not...
No. To 15 you paid, sir.
Only 15 people have been paid.
No, my lord. I have given the list, my lord, and except for your lordship may see, 56 workmen have signed it. They have received the differential. I have produced that document before your lordship.
But you have to for verifying that, you have to produce the workmen.
My lord,
you could produce only 15 of those workmen.
My lord, when they went for inquiry, they found 15 workers working there. They verified and found that there is excess payment. They should have taken the trouble of verifying everything.
No. They're saying excess payment for the 15 people.
Yes. And I have produced the list.
What about 39 other people?
My lord, I have paid. I have given the list. And no counter has been filed till by the union that disputing this
actual thing, sir. Unless the workmen come and say, yes, you have received this payment.
My lord, workmen, they went for an inquiry. My lord, they went for an inquiry. It is their application alleging that I have not paid.
Correct.
And I have produced the document that...
But you have to make good that document, sir.
My lord?
You have to make good that document by producing all of them.
Lord, if your lordship says, now, my lord, the mines are almost closed. No workmen are there.
Yes.
And if they want to make an inquiry, they can make an inquiry and find out whether this...
The short question here is, why should we interfere with this order?
My lord, having paid, can I pay double the amount, my lord?
Yes.
I have paid, and it is the finding of the court below that, my lord, they have received excess.
You have paid one thing. You have paid, then you take affidavit from all of them. And so for the
You won't be able to trace them now. That's the only problem.
that's the problem.
After so many years, my lord, they
Correct.
must,
So
whether
that
they
is
are alive or not, I don't know.
set aside the order.
But your lordship will see, he says that the differential amount has been paid.
We only have to see whether this order is a valid order or not.
But
That's all.
when I have paid the money now, can it be said that I have not paid?
You have
they
to show
put
you have
me-
paid, sir. You only showed a wage register.
Register can
And you
be
could produce only
manufactured
15
also.
workmen. Yes.
Register
My
can
lord,
be
they have not
manufactured also.
disputed my register. Question is, if they would have said that the register is false, then matter, my lord, what your lordship is saying is correct.
Yes.
They have not touched
No,
that
they
point.
have no means to find out if it's false or true.
Yes.
There is no deemed true because you do not produce a workman.
My lord, I am just a service provider.
Yes.
And the workmen are under the principal employer.
Right.
I am just providing service.
Right.
Putting them in different places as per the contract. My lord, the
You
principal
are also
did
bound,
not
sir.
produce.
You are also bound as a contractor. You are also bound to pay minimum wages. The challenge in the present petition is to
My
not.
lord, once I paid the entire money, can I be penalized for paying it
But
again?
there is now no proof available with us to believe that you have paid.
My lord, I have provided the document. The
That
court should have
document is
made
not
an inquiry.
sufficient, sir. That document can be manufactured also. Your signature can be fabricated.
My lord,
One person can
has the
put
court-
different
has the
signature for
court-
different person also.
Has the court below come to such finding?
No. It's
Yes,
the
not
other way around,
comforting.
sir. It's the other way around.
It's you. Onus is on you.
We say the odd challenge in the present petition is to order dated 20.
My lord, let them reconsider. I'll try to produce
No,
all the workmen.
No, sir.
But because why should I pay the double the amount which I have already paid?
All right. Challenge in the present petition is to an order dated 22nd December 2011, passed by the authority under the Minimum Wages Act 1948. Requiring the present petitioner to pay to the opposite party workmen a sum of rupees 422,626, which include the balance payment as well as compensation payable under the Minimum Wages Act, under Section 20(3) of the Minimum Wages Act 1948 (MW Act). Paragraph, while directing notice to issue in the present petition on 27th August 2012, this court stayed the operation of the impugned order. Paragraph. This court has heard the submission of Mr. A.P. Bose, counsel to the petitioner, and Mr. A.K. Mudali, who's for the Provident Fund Commissioner. It's not you, right? Somebody else.
They are their panel of counsel.
Or the same Mr. appearing for the petitioners. Paragraph. Mr. Bose referred to
Aurobindo Mohanty appears, no? Aurobindo Mohanty. Yes.
para 10 of the impugned order, which notes that 15 of the 54 workmen to whom the minimum wages, 56 workmen, 15 of the 56 workmen to whom the present petitioner claimed to have paid minimum wages, confirmed to having received, confirmed that they had received excess amounts. Paragraph. On this basis, it is ought to be contended by Mr. Bose that there was no occasion for the authority to impose any penalty, much less direct the opposite party. Much less direct the petitioner to make payment of the aforementioned sum to the opposite party. Stop. Paragraph. The court is unable to agree with the above submission. No, full stop. He further submitted that the wage registers showing the payments having been made had already been produced before the authority and should have been acted upon by it. Paragraph. The court finds that before the authority, the present petitioner could produce only 15 of the workmen to whom it claimed to have made payment in terms of the MW Act. In other words, in respect of the remaining 41 persons, there was nothing to show that the minimum wages had in fact been paid. None of them appeared.
39, not 41. 39.
Remaining 39.
They have noted that 39.
All right. There was nothing to show that the differential amount had in fact been paid. So this onus was on the petitioner, which the petitioner was unable to discharge. Consequently, the court is not persuaded that the authorities committed any error in passing the impugned order. The interim order is vacated. The petition is dismissed from order systems.
Special Legal List item 29.
None appears dismissed from opposition.
Special Legal List item number 30.
But 30 was with regard to management of a public duty, but the cause for which it was filed no more survives. If there is in fresh
All right.
cause of action, my lord.
Mr. Samin Mishra states that no cause of action survives at the present moment. The petition is accordingly disposed of. If any fresh cause of action survives, it will obviously be open to the petitioner to seek appropriate remedies in accordance.
Deeply obliged.
Special Legal List item 31. 31.
My lord, I may be permitted to withdraw with liberty if any cause of action survives.
All right. Same order.
Special Legal List item number 32.
None of this dismissed now.
But 32 appearing for OP number 1, Your Lordship.
All right.
Special Legal List item 33.
None appears dismissed.
Special Legal List item 34.
Malaj, I'm appearing in this case.
34. Yes, Mr. Kanungo.
34, my lords.
Yes.
Here, my lords, the main where of the petitioner is that a land which has been allotted, which had been allotted to him, was subsequently cancelled, my lords. Now, ITCO again writes the petitioner is a school, my lords. There is a land within the premises of the school. They had requested ITCO that this land is lying unutilized. Please allot the land to us at the market rate. The ITCO allotted this land at the market rate. Thereafter, subsequently, the government cancelled it, and now the ITCO has filed its counter. It has asked the government to reconsider this cancellation. May I bring out the annexures, my lords?
Yes.
The lordships may see.
No, what's the stand of the government?
Government hasn't filed its counter, and the ITCO has filed its counter at paragraph 15. If your lordship sees,
let's see that.
Page 5.
Yes.
Running page 5 of the counter, paragraph 15. That replying to the averments made in para 19 of the writ application, this deponent submits that the OP number 5, that is Chief General Manager ITCO, vide its letter number such and such, had requested the Commissioner, Special Projects, Government of Orissa, Panchayati Raj Department to reconsider the cancellation order and to hand over the land measuring 1 acre along with half constructed buildings situated in plot number such and such at Mauza Mukunda Prasad. So this is the stand of ITCO, my lords. They have already asked the government to reconsider the cancellation procedure, but till date the government has not taken a decision on this, and this land is bang in the middle of our school premises.
Why was it cancelled?
My lords, there was some confusion somewhere, my lords. That is why Annexure 1, if your lordship.
What is the nature of confusion?
My lords?
What is the nature of confusion?
Nature of?
Confusion. You're saying some confusion.
My lords, your lordships, in every administrative forum, my lords, there is always confusion.
No, what kind of confusion? What is the confusion?
Confusion is, my lords, if your lordship sees, this is Annexure 1. Annexure 1, your lordships may kindly see. With reference to the subject cited above, it is to intimate that the proposal of transferring half-constructed along with land measuring such and such has been cancelled by government, as the said property will be utilized for setting up rural self-employment training institution, which that has now been cancelled. This rural self-employment, and my lords, in the middle of the school, how can they set up another establishment? Now your lordship sees how I get this, my right to this property. I have deposited 23 lakhs and odd as per the direction of ITCO.
No, no, that has been returned to you, sir.
No, I'm
The
just saying,
technical committee headed by the RDC, he has returned the findings. What are the findings here?
my lords, my lords, your lordships may kindly say annex.
That is nearer to NH5, just half a kilometer away from the site. Adequate land was available for construction of office building. Availability of water source was easier. Since Paka Road is there to the Brunei Trust spot, no further approach road would be required. It was hygienic due to a lot of vegetation and around the site.
Lordships may kindly see the sequence of events. Lordships may kindly.
No. What was the confusion? You have still not told us that.
My lords, your lordships may kindly see. First, initially they allotted took the market price. Then your lordship says.
Is this institute still running or is it closed?
Yes, my lords. It is still. It is a school, my lords, which is running.
School.
And there's an engineering institution right
What
there.
is an engineering college?
Yes, my lords. There is an engineering college. There is a school there. And in the middle, there is a 1 acre plot. It's a 15-acre plot. The map is at running page, your lordships, for your lordships idea about the entire controversy, my lords.
No, you're not telling us the ground on which it was cancelled.
My lords, we are also not very much aware as to why it was cancelled. Your
No, the counter affidavit will tell us.
Yes, your lordships may see the counter affidavit. A counter affidavit has been filed by ITCO. It has not been filed by the government. In fact, ITCO says we have asked the government.
No.
The government and ITCO must be on the same page.
No, 1 to 3 is government only.
My lord, I have got the instructions. If your lordship will permit me, I will read the instruction what is available with me.
Yes.
This is the instruction from the RDC.
RDC.
I'm sorry.
RDC.
So I'm sorry. Project Director DRDA Khurda.
DRDA.
Yes, DRDA.
Government.
There is neither agreement signed between the petitioner and the opposite party regarding transfer of said land, nor any physical possession of the land in question has been delivered in favor of the petitioner. Then it is a fact that when government is taking a decision for use of the land in question for greater public purpose, the question of transferring the same to a private body appears unreasonable. The decision has been taken in the greater interest of the public. Their land will be used for training of thousands of unemployed youths which benefit the district. Moreover, the petitioner trust has 10 acres of land to be used for educational purpose. ITCO by letter number so and so have intimated the petitioner that the government decision regarding cancellation of the transfer proposal and utilizing the said land for setting of training center for unemployed youth, RSET, Rural Self-Employment Training Institute, will cater to self-employment training program continuously free of cost, which will be ending with suitable placement. The design of the institution is based on the guidelines of Ministry of Rural Development, Government of India. Already 28 RSCT have been set up in different districts of the state. On completion of the building, RSCT in Khurda district will be functional. Also, the placement linked skill development training program will be taken up under National Rural Livelihood Mission from the current year. So, the lease was cancelled for this purpose. That no agreement was signed with the petitioner. Possession was not delivered to them. And prior to that, we have decided to use this land for this public purpose.
No, so in response to ITCO's suggestion to you that you should reconsider the cancellation, you're basically rejecting that
yes,
suggestion.
my lord. In response to that, what the government has taken the decision, if your lordship will direct me, then I will get the instruction on that.
No, this seems to be in response to that only, what you read now.
No, my lord.
Suggestion.
My lord, ITCO is also appearing through Mr. Partha Mukherjee.
No, so ITCO says in its reply,
yes, I have
that it has asked you to reconsider.
Yes, my lord.
Now you say that has been reconsidered.
Yes, that is reconsidered. That is this parawise comment, this instruction I have received in 2000. Yes,
you
my
filed
lord.
a reply? No.
No, they have.
Reply has not been filed.
No, they filed a reply in
1 to 3 is there.
Yeah, it's there. Page 35.
This is project director DRDA. Whatever instruction you are reading, you have only filed.
There is perhaps it is not filed in shape of affidavit.
No, there is an affidavit here.
Of ITCO.
No.
Government affidavit.
Also.
Government has never given us a copy, my lord. Only counter we have received.
He's reading the instruction.
He's reading from the instructions, my lords. No counter has been.
But in the list, it is shown that filed, but it is not there in my file.
My lord, let it be passed over. I will take a copy of the counter affidavit from the file and.
It's there.
My lords, let them file.
It is there and our-
No, if it is already filed, then
No, I don't have a copy. Copy has not been served on us. Only ITCO has given us the copy.
yes, my lord. It is there, but in my file.
Or
Not there.
you say the affidavit of opposite parties 1 to 3 is neither with the additional government advocate nor
No, no,
Mr.
Miller,
Milan
it,
Kango senior
it must be misplaced anywhere in the
Any-
office.
Copies
It is
thereof
there.
be made available to both the counsel of the petitioner as well as the additional government advocate on payment of usual charges.
My lords.
There's an interim order here.
Yes, my lords.
Interim order to continue.
Deeply obliged. Deeply obliged.
My lord may fix a short date because
What short, sir? 20th September.
obliged.
Deeply obliged.
Special vehicle list item 35.
My lord, may I please, Your Lordship? All these matters are similarly placed. Now, the point over here is that we have challenged all the petitioners are the same cause of action. We have challenged the sub-collector's order. The sub-collector's order, being an appellate authority, has passed an order. Whereas the initiation is under this case is under OLR provision section 4, where we have asked for settlement of land in our favor. If any appeal lies, the appeal lies under section 58 of OLR Act rather than section 12 of OPLE Act. How can an OLR first case be transferred into OPLE appeal? The order passed by the sub-collector is based on the section 12 of OPLE Act. Our case initiation is under OLR Act section 4. There is an appeal. Appeal is under section 58, Your Lordship.
Of the OLR Act.
Of the OLR Act.
But the same authority is same. I think
authority is the same, but the application, the nomenclature is section 12 of the Act they have taken.
wrong nomenclature cannot hit the merit of the.
So when it is an appealable order, the sub-collector's order.
It is appellable order and appellate court has decided the
Your Lordship,
order is.
the petitioners have had 30 years of possession on the land. From 1989 to 2009, after 30 years of lapsing, and according to schedule article 12 of the Limitation Act, 112 of the Limitation Act, they completed the principles of adverse possession.
My lord, adverse possession plea is only cognizable in civil court. No revenue court can declare any title in favor of any private individual on the plea of adverse possession. If you have got any title over by virtue of adverse possession, then you can ask the civil court for declaration. How the revenue court can take cognizance of it?
Right.
That is the only point which the learned courts who I find in the impugned order.
Right. So
let him approach the civil court.
No, I'm saying that we should have approached under section 58. The appeal that they did was under section 12 of the OPLE Act. They changed from OLR to, if my cause of action arises, I would have gone to civil court. But we approached OLR under section 4. So the appeal provision is under 58, Your Lordship.
No, since you are saying adverse possession, you should have approached the civil
On
court.
merits, you don't have a case then. Because
Should have
anyway,
approached
these
the-
authorities cannot declare your adverse possession, title through adverse possession.
You should have approached the civil court.
Yes, if my Lordship will give me a liberty
Counsel,
to
the petitioner seeks leave to withdraw these petitions with liberty to approach the civil court for appropriate declaratory release in accordance with law. The petitions are disposed of as withdrawn with liberty is paid for. The interim orders, if any are here.
Interim order we've had.
Yes.
A time may be fixed 3 months, 6 months.
No, that's
Civil
up to you.
court, there is no time.
It's up to you.
It's not a.
How much workload?
Correct.
Lord,
Item 36.
36, I'm making an undue request to your Lordship because there's some confusion in my file because other file records have come. So your Lordships may take it up tomorrow or any other day next week, subject to your Lordship's convenience.
Yeah. Randall, senior counsel for the petitioner, states that his file has been misplaced and seeks an adjournment of that business.
I've also taken consent from the other side. Mr. Sarangi, I had requested him if I need to reconstitute, I'll take his help to reconstitute the file.
All right. Left been
I am appearing for the beneficiary will order.
Mr.
I pray for a short date.
Yes, yes, yes.
I cannot
I'm also
postpone.
appealing for it. I'd ask Amresh to give you that list of what you can read. September.
It's subject to lots of any just shorter. We are also.
We're seeing every day it's some 50, 40, 50.
I'm sorry, ma'am.
My lord, sorry, my lord, on 6th, I have some problem. My lord. Can it be on 15th of September? My lord. Sorry, my lord.
That's the first. 14 September.
The interim order.
Interim order.
Public.
Special weekly list item 37.
37, my lord, on behalf of Mr. M.B.K. Rao, kindly pass over, my lord.
All right, pass.
Special weekly list item 38.
May I please, Your Lordship? May I please, Your Lordship? Your Lordship, may kindly present order dated 24/6/2021. Your Lordship formulated 2 points to be answered by the opposite party. This is with regard to those pond drivers working on daily wage basis as per the scheme of the government.
What's the date of the order you're referring to?
Pardon, Your Lordship.
No, what were you referring to?
I am referring to order dated 24/6/2021 passed by this noble court, formulating the points to be answered by the commissioner cum secretary.
Right. Have they filed an affidavit?
But I have filed. But I have not been given a copy of affidavit.
When did you file it, sir?
Just filed 1st of November 2021.
You should have given me a copy in advance copy. As soon as you file, you should have given me a copy. No, 1st November 21, he says. But it's not on record. Even we don't have it.
And one more thing, I do not know in which case my learned friend has filed it.
In the first case, I have filed.
But that will do. But the thing is, I have not been given a copy, my lord, to assist your lordship.
I'll supply it.
All right. Mr. Mudali states that pursuant to the order dated 24 June 2021, he has filed an affidavit on
of the secretary, of the principal secretary to government in Panchayat Raj Department. On
When?
1/11/2021.
What 11? 111?
1/11.
Ah,
Probably that is
1/11/2021.
available in the first case at flag E, probably.
There's only flag D here, sir. There's no
Flag
E.
In the first case, flag E is there, but I have not been given a copy. I am appearing in 7036, that is the second case.
I'll supply the copy of this affidavit.
Because it is on my submission, your lordship was pleased to formulate this point. No, I have not been given. Possibly my
Copy
friend.
thereof we provided to counsel for the petitioner within 3 days. It's there on, not just scanned, it's there. List of. September 16. No, that's a Friday. Sorry. 19 September.
I have been given a copy. Your Lordship may record that.
Then you argue you've already been.
No, my lord, I
just
have
now.
to assist, my lord, because I have to go through.
Just now you've been given.
Just now.
Oh.
My lord, just now handed over. Your Lordship. So just to.
Government council never gives up. In every court there is a problem.
Obliged.
Special Weekly List item 39. Item 39.
One thing I'm just clarifying. My friend has given a noting in the receipt that the copy was offered to me. I refused. I'll never do that. But that noting may not be given in the receipt. That will be quite embarrassing for me because I'll never do that. I have never done that in my 30 years career, man.
This is item 38 only, no?
Yes, 38. It's a bad case.
So you're appearing in all the writ petitions, is it?
In fact, initially I was appearing, but subsequently all the briefs were transferred to my friend Mr. Pal, except 7036.
Oh, so you're only in 7036.
And on that day when your Lordship formulated this point, I had assisted your Lordship Mallory on that point, and your Lordship was pleased to formulate the point.
You have a copy of the government affidavit?
Yes, one.
Oh.
I'm receiving the copy, but this noting my friend may delete because I'll never do that.
All right.
List item 39.
None appears dismissed in opposition.
Special Weekly List item.
Noted well. All right.
Item 40.
40.
Item 40 plus no instruction.
No instructions.
The liberty.
No liberties. No.
Special Weekly List item 41.
41, Your Lordship, on behalf of Mrs. Pamirat, we just filed our appearance memo. Your Lordship, this matter is covered under Your Lordship's judgment by WPC number 26692 of 2011, Your Lordship.
In fact, I was verifying that that order state a challenge before the Honorable Apex Court.
What has happened?
The recently it has only been diary numbered.
All right. Counsel to petitioner states that the present case is covered with the judgment dated 18th April 2022 of this court in WP civil numbers 26692 of 2011, bracket Samarendra Nayak versus Union of India. Mr. Mudali states.
Your Lordship, Your Lordship, similar matter has been posted for tomorrow. Kindly keep it to tomorrow along with that other matter.
No, same order is going to be passed tomorrow also. Because if there is SLP, we'll have to await the outcome of the SLP. It is stated that especially petition has been filed against the above judgment by the
Diary
state
number
government.
22626.
Sorry?
Diary number 22626 of 2022.
Bracket diary number double.
State of Orissa versus Samarendra Nayak. 22626.
22626 of 2022.
State of Orissa versus Samarendra Nayak.
Awaiting the outcome of the above specially petition. List on. 1 minute. Oh, October is not given. problem. 18th October. 18th October.
Here also the Honorable one of the opposite party.
October. Yes, sir.
Special Equalist item 42.
To make a note tomorrow is the whole batch. Same.
Item 42.
None appears. This is not a solution.
Special Equalist item 43.
43, my lord, I am sole petitioner died, my lord. During pendency of this case, sole petitioner died. I have filed the petition for substitution in IA number substitution petition along with the limitation and setting aside abatement, my lord.
One-time settlement that you can. What is this? Is a surfacey matter?
No, my lord, surface not matter. The land has been allotted in my favor by the IDCO. That is Annexure 1 since.
What is the amount due to IDCO, sir?
Amount they have not exactly calculated as per their advertisement Annexure 4, my lord.
So if you want one-time settlement, there is no amount due or there is amount due?
No, I have as per the advertisement and my kindly see Annexure 4, my lord, running page 18. As per their advertisement, I have deposited 2 lakhs.
No,
that is OTS amount.
OTS. There must be some amount for OTS, na?
My lord.
You are asking for OTS. Considering the OTS proposal of the petition.
No, I am not asking their advertisement Annexure 4 running
Sir,
page 18.
Please don't understand the question being asked.
My lord.
Why would you go for one-time settlement? Because you owe some amount to them.
Yes, my lord.
What is the amount you owe them?
That is 2 lakhs. That is 2 lakhs 38,620.
No. When was this due? Where are you getting this amount?
That is from 2008, my lord.
Where are you getting this amount from? Where are you reading it from? This 2 lakh.
Amount reading from OSFC.
You have
Orissa
only paid 10% of the OTS amount. That is 2 lakh something.
2 lakh something I have deposited.
What is the amount that you owe them, sir? You understand the question?
Yes, my lord is correctly pointed out, but I have not mentioned in my petition.
And when did you owe this amount?
From 2008.
Today we are 2022. How much will that amount have grown to?
Therefore, I have giving a representation to the authority so far as my representation annexure.
You follow up on that representation.
Kindly calculate. As per the annexure 6 to 9, my lord.
That's all you have to do, sir. We will not sit here and do all that.
I have requested them to kindly calculate the total amount.
Whatever.
In my representation till pending, they have not submitted me.
The problem is you have not made any payment. Apart from this 2,38,000, you have not paid even 10 more rupees.
Yes, my lord.
And your outstanding has grown to some 50, must be more than a crore now. What's the outstanding amount?
My lord, I have submitted representation.
Sir, you can go on making representation, no problem. Representation costs only 5 rupees. You keep on making representation, no problem.
They have not given.
They will also not respond, sir. You every day sit in the morning, make a representation. They will also not respond. Don't make any payment. It will go on like this for 20 years. Meanwhile, get a stay order, sit pretty, be very happy. That's it.
What is the total amount, madam? What is the total amount?
My lord, the total amount, I also do not have any instructions in my counter affidavit, but
very convenient. I think this is the best arrangement that the petitioner can hope for.
No, my lord, in the meantime, an order of eviction has been passed.
There is an internal arrangement.
No, my lord, an order of eviction has been passed in the year 2015.
Have you got back possession?
My lord, no, my lord, I have not.
So that's what I'm saying. So you can do anything on paper, nothing is going to happen.
Should take possession immediately. Why are you not taking that?
I'll take instructions, my
That's
lord.
what I'm saying, internal arrangement.
The net result is matter will get adjourned, interim order will continue. He will not pay a single penny. You will not make a single effort to get back your land or the money. This is convenient to everybody, except to the court. Yes.
The outstanding amount as on 16/3/2012, as per Annexure B of my counter, is 20,38,088
Must be
rupees.
more, must be more than that.
In 2012, it
More
was
than
this amount.
that.
Now 2022 will be much more than that. If you add compound interest and all that, it will be much more.
Yes, my lord. And in the meantime, eviction order has been passed in the year 2015.
Evict him. Take possession.
My lord.
Nothing is going to happen.
I am ready and willing to settle. I am ready and willing to settle.
You are ready and willing to settle. Will you pay 1 crore tomorrow morning?
No, my lord.
Don't simply say ready and willing to settle.
My annuity is running there. My annuity is running there as per after death.
You ask your client, they will not even be ready to pay 5 lakhs tomorrow morning. That's the truth of the matter. None of them wants to pay anything. Everybody comes to the court and says ready and willing. I will make one more representation. Every morning I will counsel with the petitioner states
I will pay, my lord.
that the petitioner is ready and willing to make payment of all the outstanding amount. In fact, he has repeated this phrase 3 times. Full stop. In that view of the matter, recording the above statement, the court vacates the interim order and disposes of the writ petition.
My lord, may I
simple
submit
as
one
that,
thing,
sir.
my lord?
No difficulties at all.
I am my unit is running there. My lord, maybe directed the opposite party to give some total exact amount so that I will pay.
He says as long as the opposite party intimates the petitioner the exact amount to be paid, the petitioner is ready and willing to make all the payments. In that view of the matter, no further directions are called for. The petition is disposed of. The interim order is vacated. Simple.
And even if, my lord, within that, only within that specific period, no coercive action, my lord. I am ready. They will intimate me in the within 1 week.
If you are ready to pay, why would they take coercive action? Yeah. No question at all. The minute you say I'm ready to pay, then nobody is going to take coercive action.
But subject to they intimate me exact amount. So
Yes.
That
we have said.
Item 44.
My lord, substitution. I have filed.
All right. At the outset, the application is allowed substitution.
My lord, I have filed substitution. May it be allowed?
Yes, that is allowed, sir.
Allowed.
May I be permitted, my lords? Item 43, my lords. Since the brief is transferred, the name of Mr. Debashish Panda and Associates be removed from the cause list.
All right.
Deeply operational.
Item 44.
Item 44, my lord, the petitioner is an ex-military man. He wanted to allotment of land in his favor, my lord. After his retirement, during pendency of this writ application, the petitioner was died. And the day before yesterday, this brief he handed over to me, my lord. I have prepared the substitution of petition as well as my power, my lord.
All that is fine. Have you prepared the matter also?
My lord.
Let's argue the matter.
My lord, let me.
We'll take all that, sir. You argue the matter.
My lord, the petitioner is an ex-retired military man. He was filed a lease case number WL for 2000.
So that this is Jawan lease.
Jawan lease, yes.
Jawan lease is all over,
no
sir.
more,
The whole policy is finished.
My lord, your lords can find out annexure A/3. The government police.
You give us all your wakalatnama, everything, that 4 documents you are having.
Yes, my lord.
Please give all that. So now you will only get cash compensation. There's a new scheme. You apply under that. We'll ask them to consider. All right.
My lord, annexure A/3, government has already been filed the annexures. The getting notification. 50,000 compensation will be given to the ex commissioner.
Subject to certain satisfaction.
Correct. Now that you see this wakalat.
That is annexure A/3.
The substitution is also allowed. You say it will be open to the petitioner to approach the state under the extant policy, which only talks of compensation being paid. Since the earlier policy of granting single quotes Jawan lease unquote has been done away with. Full stop. Subject to the petitioners making such an application and subject to their fulfilling the requirement as stipulated under the present policy, the government is directed to examine such application if it is made not later than 5th September 2022, in accordance with law, and convey its decision to the petitioners within a period of 3 months thereafter, and in any event not later than 5th December 2022. No further directions are called for the petitions disposed of.
Special vehicle list item 45.
My original certified copy of the order.
45.
I'm appearing for sub item 2, my lords. 6629 of 2013, ma'am.
Yes.
Yes, I pray for a small passover.
Correct. Passover.
Special vehicle list item 46.
I note that is no instruction.
No instructions disposed of. Correct.
Special vehicle list item 47. 47.
Item 47, my lords. I'm appearing for the petitioner. My lords, the file has been misplaced.
All right. Counsel, the petitioner states the file has been misplaced. The petition is dismissed for non-prosecution.
My
With
lords,
liberty to the petitioner to revive the petition as and when the file is able to be traced. All right.
My lords, I am obliged, my lords.
Special vehicle list item 48.
None appears dismissed for non-prosecution.
Item 49.
None appears dismissed for non-prosecution.
I have the opposite party, my lord.
All right.
I have already complied the order of the honorable court, my lord. I filed the.
We are dismissing it for non-prosecution. Yes.
Item 50.
None appears dismissed for non-prosecution.
Special weekly item 51.
May I please, your lordship? My lord, I am reading the operating part of the order, my lord. This Honorable High Court directed, accordingly, this court quashes the impugned order dated 11/8/2011 under Annexure 13, passed by the Executive Officer, Brajarajnagaram Municipality, imposing a sum of rupees 4,88,900 towards penalty on the petitioner, and directs the said Executive Officer to permit the petitioner to carry on the work awarded to him, complete the balance work, and settle the bill submitted by the petitioner under Annexure 12 for the work executed by him within 2 weeks from the date of receipt of certified copy of this order. If the Executive Officer of Brajarajnagar Municipality is not satisfied with the bills submitted by the petitioner, proper measurement shall be made in presence of the petitioner or his representative as expeditiously as possible.
Come to the show cause affidavit.
My lord, after the order, my lord, I have
para 6.
Yes, my lord.
Show cause affidavit para 6.
That in reply to the para 5 of the petitioner, that work order issued by this office order numbers such and such to the petitioner for execution of the work, construction of a road from Old Gondghar to Remja with culvert was cancelled. By this office order number 2010, as the said contractor did not continue the work, first RA bill amounting rupees such and such was paid to him by voucher number 44 dated such 19/7/2010 for the work executed by him. Payment of rupees 60,194 towards second final bill for the work is construction of road from Old Gondghar to Remja with culvert had already been paid to the petitioner through account pay check bearing number such and such dated 18/4/2013 for the work done by the petitioner, and the said balance work was offered to Sri Arjun Kumar Dhal, my lord, contractor, to execute the work, which was third lowest tenders, as the second lowest tender did not give his willingness to execute the work. So work order number such and such dated 2/6/2011 of this office was issued in favor of Sri Arjun Kumar Dhal, contractor, to execute the work accordingly. Sri Dhala has completed the work and final payment towards execution of work was paid to Sri Dhala by voucher number 17 dated 5/6/2012. As the balance work has already been completed by the other executant and payment towards the same had already been made to the concerned executant, so no balance work is to be offered to the petitioner in this regard.
This was filed way back on 13th April.
My lord, in the counter they have never stated 14. Before this Honorable High Court that the work has been allotted to another person, my lord. After lengthy hearing, the matter was disposed of, and so far the balance work is concerned, my lord, I have completed, my lord. I have submitted the bill.
There is no rejoinder. 1 minute. This was filed in 2018.
Yes, ma'am.
There is no rejoinder filed. If you think that something else is due to you, you take other recourse to other remedies.
No, my lord,
there's no contempt, sir. There's no contempt here.
So far as contempt is concerned, my lord, their intention is bad, my lord. My lord, kindly have a glance to what is the order, my lord, passed. They have to take measurement, my lord. Whether they have taken
whether or
measurement,
not-
they have not taken measurement,
Yes,
my lord.
yes. We
They have
can't,
not paid me.
we can't adjudicate that here, sir.
My lord,
We cannot adjudicate that here.
no, my lord, only to educate whether they have to comply with the order of this honorable High
Yes,
Court
yes.
or not, my lord.
Yes.
In my para, my lord, I have mentioned, my lord.
Whether they have measured or not measured.
So you have not filed a rejoinder. They say they have taken measurement. You don't file a rejoinder. That's the end of the matter.
My lord, let it come, my lord. I have filed, my lord.
No,
At
no.
least they have to submit the documents, my lord, whether
All
they
right.
have been paid to me or
All
not,
right.
my lord.
All right.
Whether they have been paid to me or not, they have not filed a single document before
Right.
this honorable High Court.
Right.
And while the writ is disposed of, there also they have not stated anything.
Right.
So far, the work has been allotted to another person. And this honorable High Court, please to direct to give me the work order. In para, I have mentioned. My lord, if the executive officer of Brajrajanagar municipality is not satisfied with the bills submitted by the petitioner, proper measurement shall be made in presence of the petitioner or his representative as expeditiously as payable, my lord. That the order of the honorable court is clear and unambiguous and not capable of more than one interpretation. The 2 weeks as stipulated by this honorable court has already been passed and the petitioner has not yet been permitted to carry on the balance work and the bill submitted by the petitioner has yet not been settled, my lord. The opposite party defeated the very meaning of judgment and the petitioner received an unfair deal, my lord. That the act of non-permitting the petitioner to carry on the work and non-settling the bill submitted by the petitioner is done voluntarily by opposite party with specific intent to do something the law forbids, and with the specific intent to fail to do something the law requires to done with evil intent and bad motive for the purpose of either to disobey and to disregard the order of this honorable court, my lord. Nowhere they have filed a single paper before this honorable High Court.
The petitioner is agreed by the non-compliance of an order dated 15 November 2012 passed by this court. In writ petition civil 32940 of 2011, whereby the opposite parties were asked to settle the bill submitted by the petitioner for the work executed by him within 2 weeks from the date of receipt of the certified copy of the order. It was further observed that if the executive officer of the Brajrajanagar municipality is not satisfied with the bill submitted with the petitioner, proper measurement shall be made in presence of the petitioner or his representative as expeditious as possible. Paragraph. In response to the notice issued in the present contempt petition, a reply has been filed by the Ashoka's affidavit has been filed by the executive engineer of the municipality on 15th April 2018, where inter alia, it is pointed out in para 6 that the petitioner was paid rupees 60,194 towards the second and final bill for the work of construction of the road from Old Gandaghora to Rimja with culvert. Paragraph. It is further pointed out that the balance work was offered to another contractor. And the said contractor has also completed the work and he has also been finally paid. There is now no balance work to be offered to the petitioner. Paragraph. There has been no rejoinder filed to the above counter affidavit for over 4 years now. So in other words, there is no denial of any of the averments in the counter affidavit. Paragraph. Counsel, the petitioner kept insisting that the measurements had not taken place in accordance with the directions issued by this court. Full stop. It will be recalled that such measurements were necessary only if the bills submitted by petitioner were not acceptable to the municipality. Full stop. There is no such averment in the counter affidavit. Full stop. The stand of the municipality is that in response to the bills submitted by the petitioner, it has already made payment of rupees 6194. Paragraph. Consequently, the court is of the view that no case is made out for further proceeding as far in the contempt petition, since the court is not satisfied that there has been any willful disobedience of the directions issued in its order dated 15th November 2011. 12, sorry. Is it 11 or 12? 12. Leaving it open to the petitioner to avail other appropriate remedies as may be available to the petitioner in accordance with law for any other grievance that the petitioner may have, the petition is disposed of.
So local list item 52.
My lord, item 49, I am extremely sorry, your lordship, the petitioner is deceased. Only I am extremely sorry to. Item 49, the petitioner is deceased.
All right. 49 is the petitioner stated to be no more. The petition is disposed of. All right.
My lord, obliged.
But in this case, item number 52, in pursuance of the law, this honorable court's last order, a counter affidavit is being filed today. Pray for 3 weeks' time to file a rejoinder.
Rejoinder will be filed for the next date.
Okay. This is a matter where the order of the CAT is under challenge.
21st November.
My lord, I have filed the counter affidavit that may be taken to record, my lord.
Yes, yes.
Okay. Special local list item 53. Item 53.
No, please, this is not possible.
Special local list item 54.
No, please, this is not possible.
Item 55.
My lord, item 55, there is another connected matter of the self-same property passed by the same order, that is 13,582 of 17.
Oh, this is a disposed of case.
No, my lord, it is not disposed of. That's the mistake, my lord.
Oh, I see. List along with?
My lord, 13,582 of 17.
13,582 of 2017 on 21st November.
Special local list item 56.
My lord, interim order maybe.
I don't know if there is an interim
Yes,
order.
ma'am.
If there is an interim order, you can't.
My lord has
That,
posted.
noting dispose of case has to be removed.
My lord has posted.
Give him the date.
21st November.
Obliged.
Special local list item 56.
Nana PS, this is not possible.
Special local list item 57.
Well, in the year 1973, my lord, a piece of land was settled in favor of one Khudiram Sai, my lord. The Khudiram Sai in the 1992 sold the property in favor of the petitioner, my lord. In 2002, the land was resumed by under section 3B of the OGLS without.
Yes. All right. The impugn order of resumption is dated 14 January 2002 in WL case number 108 of 1973, whereas the land was sold to the present petitioner by registered sale deed
24th August
on 24th August 1992. On the short ground that the impugn order was passed without notice to the petitioner, comment is hereby set aside. WL case number 108 of 1973 is restored to the file of the Tahsildar Bhubaneswar for being proceeded with after hearing the petitioner, in accordance with law. The petitioner will appear before the said authority on 12th September along with a downloaded copy of this order. First of after hearing the petitioner and other interested parties, the Tahsildar will dispose of the said WL case number 108 of 73 within a period of 4 months thereafter. Till such time, the status quo order passed by this court No, there is no interim audit. Till then, status quo be maintained in respect to the property in question.
Special utility item 58.
The memo is taken on record, disposed of, is not trust.
Special utility item 59.
59, my lord, should PIL for with a prayer for shifting of the IML offshore from the educational area. Your lordship will
So
find.
now it's all infructuous, sir.
All infructuous.
There's the new policy has come. It will all be functioning under the new policies. You make a new representation of a cause of action.
I have filed the representation before the collector.
In 2012.
When did you file?
10 years ago. So if there is any cause of action, you file a.
Whether that shop is running or not, that is
That also nobody knows. We said due to effects of time, it is doubtful that the cause of action survives. If any cause of action survives, it will be open to the petitioner to seek appropriate remedies in accordance with law. The petition is disposed of.
Special utility item 60.
60, I am for the opposite party.
None appears. This was not also.
61.
Item 61, may I plead, your lordship. The petitioner's land were taken by the government of Orissa, your lordship, for construction of bridge and road, your lordship, without acquiring the land or without giving the compensation, your lordship. From the noting I found, your lordship, one affidavit was filed by the OP number 2.
What is the total area? Total area?
Pardon, your lordship?
Total area acquired? What is the total area acquired for?
Total area, your lordship.
Never prepared.
You have said 200, plot number 207, 211, 210.
Yes,
What is the total area?
Total area, lordship, 0.76 acre, your lordship.
Acre. They have not paid you anything.
Yes, your lordship. Your lordship may peruse the annexure 2, your lordship. Brief. They have admitted. One affidavit was filed by the OP number 2, your lordship. That copy was not served upon me, your lordship. What I found from the noting, your lordship.
You had filed an additional affidavit, Mr.
There
Malvi.
is also another additional affidavit.
9 January saying you're taking
And you
steps
have
to
filed
having
rejoinder
private
affidavit.
purchase.
There is a rejoinder affidavit filed by the petitioner also.
No, but after that you filed a further affidavit.
Yes, your lordship.
Saying that steps have been taken for direct purchase.
Yes, that is our stand in the original.
That is in 2012, sir. What have you done? 2017.
Have you paid?
The last 5 years, what has happened?
Or still taking steps?
An additional affidavit was filed on 9 January 2017 stating by the state, stating that steps have been taken for purchase of the land of the opposite parties through single quotes direct purchase paragraph. A further affidavit shall be filed updating the status on or before the 5th September 2022 with an advance copy to constable petitioner. Is there an interim order? No, there's no interim order. List on. September.
5th September.
15th. But you filed the affidavit by 5th.
Yes, ma'am. The current status, I will.
Copy of that affidavit may be.
Of course. I will.
Give a copy before you file.
Yes.
And that's what said in the order.
That counter affidavit is already served because he has filed rejoinder to
I am
that.
reminding the government again and again, please give a copy. This is your duty.
Yes, my lord.
You are not doing any favor to them.
No, I will give. That further affidavit, second affidavit has not been.
No affidavit is given. Only he is given here only after.
Yes.
Item 62.
May I proceed, Lordship? My Lord, kind permission, my Lord. My Lord, the petitioner has prayed this honorable court to direct the, my Lord, the opposite parties to, my Lord, to encourage the market for the non-conventional energy source in compliance to the OERC direction, my Lord, about the renewable and cogeneration purchase of public. And the, my Lord, the OERC has framed regulation to, my Lord, how the renewable energy.
These are very vague, sir. These prayers are very vague. If any cause of action survives, you make a proper representation.
Lordship, that my recommendation is
Counsel for the petitioner seeks leave to withdraw this petition with liberty to file a fresh representation with the authorities if any cause of action survives. Disposed of is withdrawn with liberty is free.
Special Utilist item 63. 63.
Well, this is a demand under the Entry Tax Act. I have challenged the reassessment order.
This is appealable, sir.
No, my lord, appealable here, they have not issued the notice, neither issued the notice nor given any opportunity of hearing. Totally, they have not issued the notice. Kindly have a glance to.
No counter file, nothing, sir. We'll let you file an appeal. It's permitting the petitioner to withdraw the present petition.
No, this covered by our Orissa High Court judgment, my lord. I am giving that judgment also.
True that.
Without?
True that.
Because they have issued the notice under the VAT Act and assessed the nil. But surprisingly, they passed the order under the Entry Tax Act. Kindly have the provision, that section 10.
Where is the notice? Copy the notice.
That they have not issued a notice. That page 8, annexure assessment order. This is order of assessment. Kindly have page 8, my lord. This is assessment order under section 43 of the OVT Act. But this order has been passed under the ET Act.
That has been corrigendum order has been passed, Your Lordship. That is the apparent mistake, Your Lordship. At page 7.
But I have not got that order.
Page 7, the assessment has been completed under section 10. But it is the in so far as the first line, it is copy pasted, and subsequently the record is with me. The record is with me, Your Lordship. And subsequently at page 67, a corrigendum rectification order has been passed and issued, Your Lordship. So that 10, no, that is in my record, Your Lordship.
No. You've not, as far as the present petition is concerned, no reply file, nothing, sir.
Your Lordship.
So if you admitted that it's a mistake, then a fresh order will have to be passed. Mr. Sunil Mishra.
Kindly have a glance to that judgment I have given.
Refers to his original record and admits that the impugned order at Annexure 1 has been mistakenly issued as an assessment order under section 43 of the OVAT Act, when in fact it should have been a reassessment order, is it?
Yes, sir. Under the Orissa
Entry Tax Act. Paragraph. Since the mistake is obvious, the impugned order is hereby set aside, and all the consequent demand raised pursuant thereto is also hereby set aside. The petition is disposed.
No, Lordship. Subsequently, Your Lordship, that rectification has been
that made. He is not challenged. So whatever he worried, this is the original order.
The correction I have not received, my lord.
And that rectification order you've served
only that portion, Your Lordship. Your Lordship.
No. Have you served the rectification?
Your Lordship, that has been sent to its recorded address, and comment is that the address Odia, that is the note that has gone to there, and since the office has been closed, so it has been intimated, Your Lordship. It has been affixed, Your Lordship.
So, my lord, I have got the certified copy of the order sheet.
Your Lordship, correct.
I have got the certified copy of the order sheet also.
Entire record is here.
Nothing mentioned in that.
So only Your Lordship, so far as the
on this rectification order, you don't seem to have placed it on record here. He does not have a copy.
Only that portion, Your Lordship. So far as the issue of notice, Your Lordship.
But without issuing the notice, they have passed the order.
This honorable court.
Without issuing the notice, they have passed the order.
Your Lordship, this honorable court in identical circumstances has passed the order that this is, but so far as the assessment under section 9C, Your Lordship, audit assessment. On same AVR, even on same AVR under VAT Act, assessment under Entry Tax Act can be passed.
No, but here you have not passed it under the Entry Tax Act.
Your Lordship, Entry Tax Act. Only that mistake is there, 43. In the past, Your Lordship,
but not placed the rectified order. Only today, for the first time, you're showing us.
Your Lordship, at page 7, Your Lordship, may kindly enter language is Entry Tax, but only that first paragraph, that is 43, has been written. So enter language. So far as in the first page, in the format that is section 10. And your lordship, the language and that class, your lordship, the demand has been raised on
Page
the
8 to 12 is verbatim. What is the VAT Act? Totally copy paste.
At page 13.
VAT Act, that is the order they have copy and paste in the IT order. That
Yes.
page 8 to 12. And in the, I have also enclosed the VAT order. Kindly have a glance to VAT order, page 16. Totally copy and paste.
Page 12 is there.
Who have mentioned about the entity tax?
13 entity tax.
That is
Because the same third case report, 43 and as well as 10 has been initiated. And your lordship, for that reason, it has been, the first line has been copy pasted, your lordship. So, sir, at page 7, it is section 10. At page 13, it is section 10. The demand has been raised under section 10. The finding is under section 10.
This is an appealable order.
Your lordship.
But they have to issue the notice. Kindly have a glance to section 10. Just I am placing my.
You raised that in the appeal, sir. You raised that in the appeal.
But without notice, without any confrontation, I have to file the appeal.
That the corrigenda was issued on 31st.
But totally natural justice has been violated.
Approach to the correcting the first line of the order as an order issued under section 10 of the OET Act. He says this was also, copy thereof was also pasted on the last known address of the petitioner. Paragraph. In that way, the matter will be open to the petitioner to assail the said order in accordance with law by way of a statutory appeal. So if such appeal is filed not later than 5th September 2022, accompanied by an application for continuation of delay, citing the pendency of the present petition as the reason for the delay, then it will be considered in accordance with law by the appellate authority. The court clarifies it is not expressed anywhere in the matter.
No, annexure want to be returned.
In the event of the appeal being filed within the aforementioned time, accompanied by an application for interim leave, then till such time that the appellate authority passes an order thereon, the interim order passed by this court on 5th August 2014 shall continue.
Annexure want to be returned.
Annexure 1 be returned subject to being substituted with attested photocopy.
Special Utility Item 64.
I may please your lordship, and I'm on Rishi, madam.
Yes.
And the order at Annexure 12 is under challenge before lordship. That is the order passed by the Lawrence State Administrative Tribunal. The case in sought before lordship is the petitioner was initially appointed as a class court under the CDM of Denkanar in the year 2000, madam. But he possessed the +2 science qualification in his favor. Supervisor from 2000, madam. Since he has the qualification and 2 vacancies were created, in 2009 he was allowed to continue on regular basis as a supervisor, as a TV visitor, madam. And that was challenged by a class court employee who has no educational qualification to challenge. Lordship, can you turn to the state counter at page 21? State counter, madam, page 21. Page 21, Lordship, can you see wherein the state has also categorically stated that the individual opposite party has no educational qualification for consideration. In spite of that, tribunal has directed you make recruitment for all the class 4 employees, even they don't have the educational qualification to hold the post. And meanwhile,
have all of them been served? Has opposite party number 4 been served?
Yes, madam. I'm told he served and he has been promoted in another line, therefore perhaps he's not appearing. It was sent to the registry post with the AD, madam. AD not returned as it reflects.
Yeah, not back from opposite party number 4.
Yes.
Is he still in service?
Also I have 13 years in the same post because I have been continuing from 2009. And opposite partner 4 is promoted to another area, therefore perhaps he has no contest. Be that as it may, look at the state counter ballot, page 21.
Yes.
State has clarified that the individual opposing party has no locus standi and I have possessed the requisite educational qualification, considering the everything, and by virtue of the tribunal order, they considered and given me appointment. That is state stand, madam. See, look at my lord.
So here your stand will not be any different, Mr. Mudali.
Copy of letter in 5-6.
Your stand here cannot be different. There you supported the petitioner.
That has been negated by the land tribunal.
That's a now he's not here to support that order. Opposite party number 4 has stayed away.
My contention is, if somebody has no educational qualification to hold the post, cannot challenge the matter before the
Correct.
lordship.
Correct. You see, the challenge in the present petition is to an order dated.
But latest instruction in the present petition, I have received the instruction that is contrary, obviously that is contrary to the stand taken.
Everywhere you have to oppose.
That is both the petitioner.
When he files, you'll oppose. When this man is also, you oppose.
Both the petitioner as well as the opposite party number 4, they are not having the requisite qualification to hold the.
There you did not say that.
Can they take a plea contract to the affidavit? Can they take a plea contract to the affidavit?
No, that's what. You say the challenge in the present petition is to an order dated 13 March 2013, passed by the Orissa Administrative Tribunal in OA number 433 of 2009, filed by opposite party number 4, while issuing notice in the present petition. On 3rd May 2013, this court stayed the operation of the impugned order of the OAT. Background facts are that the aforementioned application was filed by opposite party number 4, questioning the appointment of the present petitioner as ward attendant in the district headquarters hospital in Venkanal, bracket DHH. No, questioning the appointment of
health visitor.
Of the present petitioner as health visitor, bracket TB, at the district headquarters hospital in Venkanal. Paragraph. In response to the petition, the Deputy Director of Health Services pointed out that apart from work experience in the TB ward for more than 5 years, the petitioner herein also possessed the requisite qualification of having passed +2 in science stream. As far as the opposite party number 4 applicant was concerned, he did not possess the +2 science qualification. Paragraph. Before this court, opposite party number 4 has not appeared. The state has also not filed any counter affidavit. Although Mr. Mudali states that instructions have been received that even the petitioner does not possess the necessary qualification, this would be completely contrary to the counter affidavit filed before the OAT, where it is clearly stated that the present petitioner possessed the necessary qualification for the post of health visitor, bracket TB. Paragraph. Mr. Kali Prasanna Mishnal and senior counsel appearing for the petitioner states that opposite party number 4 has also got since then promoted and therefore is perhaps no longer interested in pursuing this litigation. So the fact remains that as far as the post of health visitor, bracket TB is concerned, on the showing of the state government, opposite party number 4 did not possess the requisite qualification. In that event, you ought not to have been permitted to question the appointment of the present petitioner before the OAT. Stop. On that short ground, the impugned order of the OIT is hereby set aside. The petition is allowed, but in the circumstances, no order system.
Special weekly list item 65.
Item 65, your lordship has passed the order, similar order, in WPC number 7227/2013 on 18th July, your lordship.
Order. In view of the order dated 18 July 2022, in writ petition civil 7227 of 2013, bracket Gulf Corporation Limited versus State of Orissa. These petitions are also dismissed on the same, in the same terms. 65 and 66.
Same, my lords, same matter, but only thing, I saw the lordship's order. The grievance here, my lords, the Supreme Court directed for reassessment, and admittedly they have done some recomputation. I've gone through lordship's order.
Very detailed order, sir.
Very detailed order. I got your lordship's order. It's a detailed order. The counter is also. My respective submission is this, my lord. This contention of mine can be recorded that if it's a reassessment, I had a right to be with them to assist them reference to the document.
They're not adding anything.
Well, admittedly, let's see, admittedly, para 9, they have given the recomputation figures. The figures have reduced. The figure is that is a bona fide claim on my part to carry the matter up to Supreme Court and follow here because it's admittedly reduced. Well,
you were the petitioner there also.
Pardon?
You were the petitioner there also in that matter.
The previous matter. In fact, my colleague was there. I was supposed to be there. I was absent.
All right.
Only this much, Roshni, kindly record.
No, sir. Just, yes.
Special weekly list item 67. 67.
And appears this was not possible.
Special weekly list item 68.
68, my lord, here all the petitioners are bona fide purchaser. They purchased the scheduled land.
89 it 2002.
All right. On the short ground that the
here,
order of the ADM, is it?
No, additional Tahsildar. Resumption under section 3B of the OGLS.
Yeah, of the additional Tahsildar, Bhubaneswar, dated 4 June 2002 in WL case number 836 of 72 was passed. You say resuming the land was passed without notice to the present petitioners who had purchased the land in question under registered sale deed on 30th May 1989 itself. Some other impugned orders hereby set aside. WL case number 836 of 72 is restored to the file of the additional Tahsildar and will be listed there for hearing on 14 September. The petitioners will appear before the said authority on the date along with the downloaded copy of this order.
Petitioner number 1 already died, being affected by the COVID-19. But I got this information.
It is stated that the dependency of the present petition number 1 has died. His LRs will be permitted to pursue the matter before the additional Tahsildar Bhubaneswar. You say the additional Tahsildar will dispose of the said WL case within a period of 4 months thereafter. Till then, the interim order passed by this court on 16th May 2013 will continue.
Interim order to continue.
Special weekly list item 69. Item number 69.
None appears to assist number.
Item number 70.
My lordship, in item 70, the opposite party number 2 has been died. So the matter has been settled out of the court. So today we are filing our memo, my lordship.
Counsel, the
I am asking for the opposite party.
Has filed a memo stating that the parties have settled their disputes.
Special weekly list item
Accordingly, the petition is disposed of in terms of the memo filed before this court. The interim order is vacated. Right.
Item 71.
None appears to assess a non-possible.
Item 72.
My lord, in this case, my lord, no counter has been filed, my lord.
So tell us what the matter is, boss.
My lord, 356 acres of forest land, my lord, converted, the Kisama has been converted for the purpose of
EIL.
It's okay. It's good.
My lord, in the meantime, the party sought to be added, opposite party number 11, my lord. In the meantime, the company already has been changed from OCL India Limited to Dalmia, my lord.
So if any cause of action survives, you make a fresh representation.
And liberty may be given.
All right. Counsel, the petitioner seeks leave to withdraw this petition with liberty to make a fresh representation if any cause of action survives.
Right. I'm pardon. Item 71, my lord. It is also PIL. I'm sorry. Item 71, my lord.
1 minute, sir. Let us finish 72 and then we'll hear.
An item is going on in between.
The petition is disposed of in the above terms, which liberty is paid for. Yes. Now tell us 71.
Yes, my lord. Here, the petitioner has filed this PIL. Seeking for a doubt. It was notice was issued since long. Other side is filed.
What is the PIL for? What is the cause of action?
Yes. They have not strictly adherent to the provisions of the 2013 Act while acquiring private land for the purpose of construction of any project.
Sir, all this is you have to give specific instances.
Which project?
You can't just make a sweeping prayer like this, sir. You'll have to give us specific.
Which project you are talking about?
Yes, you'll also kindly come to Annexure 1.
Which project you are talking about, Mr. Joshi?
No, you'll also see the Annexure 1, page 18 issued.
Which project?
Not with regard to any specific project, my lord.
Which specific project?
No, he says not with regard to anything. So.
Any specific project because
you have all the land honesty you are appearing for so many land honesty, you don't have any problem. Today project has become problem.
Because I was a victim.
Thousands of land honesty you have appeared.
I do admit it. I was a victim.
And now you are saying the project has problem. So both sides can't work like this.
No, you'll also just one thing that will clarify. You'll also that.
I remember these lower Indravati.
Yes,
not less than thousands, I think more than 2,000, 3,000 petitions you have filed. I have heard so many matters.
Because that is with regard to
that is not a problem.
That is not with regard to non-disbursements or displacement.
Now the displacement problem was there.
No. Here, University Annexure 1, page 18 was issued by the Revenue and Disaster Management Department.
So anyway, para 11, they've denied. Whatever you're saying in your petition, they've denied.
No,
they said strictly adhering to the provisions of the Act and rules. And they're also paying additional market value at 12%.
Yeah,
the benchmark value.
Yes, they have admitted, my lord.
But no, they are paying 100% solation. That's what they say.
Please, Milods, I'm appearing for the state. I'm sorry, Milods, I'm appearing through VC. Milods,
with that observation, you have to be disposed of, my lord.
All right. In response to the petition, in counterpetition filed, in para 11 of which it is stated as under, reproduce page 32, para 11. That view of the matter, no further directions are called for the petitions disposed of.
Special Weekly List item 73.
Item 73, your lordship. I have no recent instruction, your lordship. May I dispose?
No instructions disposed of. All right.
Special Weekly List item 74.
This is PL in respect of illegal mining of sand from river Boitrini escape.
So if any cause of action survives, you make a fresh representation. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to make a fresh representation if any cause of action survives. The petition is disposed of, liberty is paid.
75.
May I please? In this case, after getting notice from this honorable court, the opposite part number 8 to 11, who are the encroachers of the government land, there is 9 acres 73 decimals. They are partially evicted by the state government, my lord.
So if any cause of action survives, you make a fresh representation.
Yes.
No, they have already been evicted. What is saying?
Yeah. Anyway.
Not partially evicted.
Partially evicted. All right. Same order. Same order.
Special Weekly List item 76.
My lords, I am for the private opposite parties.
In which matter, sir?
My lord, 75.
That's over, sir. Now. Sorry.
Item 76.
Item 76, my lords, would
Yeah,
be
yeah.
factual.
Memo is taken on record, dismisses, withdrawn. All right.
Weekly list item 77.
None appears. This is not possible.
78.
And I am for the petitioner in this case. The petitioner and other persons are residing at Kotak in government land since more than 50 years. An encroachment case was started by the Tahsildar challenging which they filed WPC.
Sir, this is not a writ petition. For settling a land in your favor, you can't file writ petition, sir. There are other provisions in the law. These are not matters for which writ petition will be entertained. Counsel of the petition seeks leave to withdraw the present petition with liberty to seek other appropriate remedies as may be available to the petition in accordance with law. The petition is disposed of, withdrawn with liberty as prayed for.
Sir, weekly list item 79.
None appears. Dismissed on opposition.
Item number 80.
79, in fact, this was filed by the Bar Association. In fact, this was stayed by the
cause of action survive anymore?
because there is a letter of the Honorable Apex Court.
That they withdrew it there to file it here, sir. That's what has happened. Okay. All right. None appears. Dismissal on opposition. Yeah.
Pass over. Special weekly list.
80 is over. 80 is over.
80. That item 80. Called it. 80. The last item was called 80.
None appears. Dismissal on opposition. All right.
My lord, on behalf of Sri Bimbisar Das, my lord, we are appearing for opposite party number 1. The
All right. All right.
Pass over. Special weekly list passed over matter item number 20.
So in this case, the question of law bills, that is there bills in page 26 bills.
Yes.
Yes, straightway I am taking my lord's attention to the impugned order passed by Lord Tribunal bills. Page 47, your lordship may kindly see for a moment.
Yes.
Paragraph 4.
Yes.
After hearing both sides at length, going through the grounds of appeal of both sides, orders passed by the lower forums, we find that the only dispute remains for consideration before this tribunal is whether the dealer received the consignment under waybill dated 31/10/87 or not. The only question. In fact, the fact remains that maintenance worth of rupees 2,04,131 have not been accounted by dealer. Fact remains that the dealer from the very beginning have taken a stand that the consignment are only received through the transporter, namely ATC, and none else. And secondly, the registration number as found in the said waybill number 4130, whereas the registration number is 1130, and the name is through transporter, namely Carico. It is contended that by Mr. Kedia, the Land Counsel for the dealer, that the waybill dated the same does not belong to the dealer, and as such, the said consignment have not been received by the dealer. So the conclusion arrived at by the learned SCST is not acceptable. On the other hand, Mr. Moon, the learned additional research supports the conclusion arrived at by the learned. Now, from the rival contention, we are unable to accept the contention raised by Mr. Kedia as the learned counsel for dealer because for the following reasons. One reason only, because I am reading paragraph 1, subclause 1. The documentary evidence produced by no documentary evidence produced by Mr. Kedia to show that the dealer used to receive medicines from Calcutta only through the transporter, namely ATC and none else. Because this is how that impelled the Lorraine Tribunal not to accept my contention, even though I have not received. Now, my lords may kindly see the document which I have annexed, and that is also dealt in by the First Appeal Authority bills. Your lordship will find annexure 5 at page 50 bills. I have shown an affidavit to that effect.
So this is only a revision petition, it's not
Yes,
an
Your Honor.
appeal. So no substantial question of law here. Purely
That's,
factual, purely factual.
Members, as a matter of fact, your my lords knows, if there are materials to support any conclusion of Miller's escapement, yes, that may be good ground. But supposing materials are there not considered, Millers, oblivious of material and
This is
admitted.
a affidavit, self-serving affidavit. Sir. So it's
Not only affidavit, not only affidavit. Next, Millers. Now, I am not stopping here, Millers. Just a minute. Annexure 6 is the Millers. There are Millers, your lords may kindly bear in mind. 2 consignments accounted for, supported by bills. I have Annexure 6 is the bill.
True. The only question is, did you also have a consignment through CC company? That's all.
Yes.
Nobody is saying you do not engage ATC. The only question is that consignment came through another transporter and whether you engaged it or not. That's the only question.
Exactly. And your lords may kindly see confirmation, page 53. There is a confirmation also.
No, of ATC only. So that's why negative proof you can't have. That's the whole problem.
Exactly. That is what your lordship decided also. I cannot read negative evidence. That is that is your lordship judgment.
No, but you've received a consignment. The whole problem is how did this consignment come? Where did it come from?
Mirrors, that is not my consignment through ATC. I have accounted for that is to Carico, and that I have not. And ATC has also confirmed. Right, annexure page 53 has confirmed from transporter also.
Yes.
So can the law and tribunal say, in spite of all
No, you
evidence,
could have examined Carico. It must be it's not a fictitious character. Call somebody from Carico, he'll say, no, these guys never engaged me. That's the end of the matter. That's how you should prove it, sir.
Correct. My lords have already said that negative evidence.
No, that's true. That's a different context.
Detailed analysis have been done by the first appellate authority. And
These are revision petitions by the SSC assailing orders of the tribunal for the years. A common order of the tribunal dated. The date. Date is not clear, sir.
Let's see, part 20th August 2001. 20th August.
20, is it?
20.
August 2001. In essay numbers.
Two 2693 26-2694 1993-94.
No, there are 2 years, sir.
Yeah, let's see. This
Still unreadable.
87, 88.
No, 93, 94, sir.
Period bills. Period bills annexure 1.
period 87,
87, 88.
Oh.
The first one, I think 2693.
Your lordship is looking at
That's only the year of the revision is that.
87, 88.
Only 1 year. But how come there are 2 petitions?
Yes, one is Odisha additional sales tax, one is OST.
Oh.
By then, there was a Odisha additional sales tax.
I see.
Was there.
Common order passed by the tribunal in 2 appeals of the
Oh, yes.
No, there's one cross appeal, sir.
Your lordship, cross appeal is there because the suppression was established by the assessing officer 7,86,313. So that suppression has been reduced by the first appellate authority after clear analysis to 2,04,000.
That has been upheld.
Your lordship.
Now, Lord and Tribunal dismissed both the appeals.
Both the appeals have been
State appeal, my appeal.
Dismissing both the state's appeals as well as the SSC's appeal for the year 1987-88. Full stop. Till date, you say by the order dated 4th March 2004. The question that was framed for consideration was whether there were materials for enhancing the turnover by 10 times in respect of suppression of rupees 204,131. On the same date, an interim order was passed directing the petitioner to pay a sum of his 1 lakh, subject to the balance amount, recovery balance amount being stayed. The short question before the sales tax officer was whether there had been a suppression of
First appellate authority has given the detailed analysis at page 36, 37, 38, page 37, 38.
no, there has been suppression of sales in respect of rupees medicine, sales of medicines worth rupees 204,131, which had not been accounted for by the petitioner dealer. Full stop. This particular consignment had been received through a transporter, namely carry company. Stop. Paragraph. The case of the petitioner was that it normally received all its consignments only through Messrs. ATC as transporters, and therefore the above consignment was not received by it at all. So this has been disbelieved by the tribunal by holding that no documentary evidence was produced by the petitioner to show that it used to receive medicines only through one transporter, namely Messrs. ATC. Paragraph. Mr. Saul, on a senior counsel petitioner, refers to the affidavit of the chief accountant of the petitioner, stating that it received its consignments only through Messrs. ATC, enclosing certain bills and a letter of ATC. Paragraph. The above documents still do not demonstrate that the consignment received by the petitioner of medicines worth rupees 203,141 did not in fact pertain to it at all. The better course would have been for the petitioner to have summoned someone to come in from Carry and Company to show that the said consignment was not received by the present petitioner. Paragraph. For the aforementioned reasons, the question framed is answered in favor of the department and against the SSC. Petitions are dismissed.
Yeah. Okay. Pastor matter item number 26.
May it please your Lordships.
Yes.
Two analogous appeals minutes arising out of judgment dated 6/7/2011. Lordship, may kindly have a glance at the impugned order, the relevant portion at page 129 of my appeal memo. First sub-item minutes, 280. The operative portion minutes reads as taken into consideration the report of the district project coordinator since the order was quashed by this court and the matter was remitted back to the OP number 1. This court, while setting aside the impugned decision taken by the government by letter dated 13/12/2010 under annexure 9 in WPC number 1327 of 2011, directs him to inquire the matter afresh as per the directions made by the court in the earlier writ petition and to consider regarding amalgamation of the two institutions to one institution and give other consequential beneficial relief to the institution strictly as per the guidelines of the government. Now, Milos, what has happened? This order was challenged before this honorable court. The order has been stayed by order dated 38/2012. Milos, I have filed an additional affidavit. Your Lordship may find additional affidavit dated 30/12/2019, wherein I have brought in a resolution wherein Milos, the collector come district magistrate has addressed a letter to the AG office of this honorable court, Milos, stating that the amalgamation of both these schools has been agreed. And the meeting was held with the chairmanship of the collector, sub-collector, BDO, and other officials' minutes. Now, Lordship may see the affidavit dated minutes 30/12/2019, Lordship, annexure 8, page 5. the third paragraph, my lords, if I may permit it to place. The collector, district magistrate Kendrapada, expressed his concern for safety of the children studying in the school as the school is running in an old building. He also expressed his displeasure for delay in development of the school building due to dispute between the villagers. He motivated villagers to discard their dispute and asked them to work for the development of the school so that the students can get appropriate learning of the environment. The villagers of Kuldia and Chandannagar, these are the two disputed villages, my lords, under the block of all in the district of Kendrapada, were asked to give their names on the views of the school. After a long discussion, it was unanimously decided that the school is to be renamed as Government Gopabandhu Chandannagar Kuldia School. And the next page, my lords, it is pending consideration before the collector. My lord, my only submission is the entire dispute can be brought to an end if this entire exercise is being done by the collector and the schools are being amalgamated, my lords.
No, but why did you appeal and get a stay then? That's what the single judge ordered, right?
I may be pardoned, Millers.
No, the single judge ordered the exercise to be completed.
Millers, in between the exercise, Millers, your lordship is asking about this affidavit, Millers?
No. See, you have come you are the school, right?
My lords, I am the management committee of the school. There were two set of writ petitions.
Correct.
My lords.
No. So the impugned order would have brought you to the same result, wouldn't it?
Millers,
because it was only asking the inspector to again inspect the schools afresh.
Admitted, your lordships, but this was done at a belated stage. I bow down to what your lordships has stated. But this entire exercise has been done only in the year.
It unnecessarily got delayed for the last 10 years.
I bow down, my lords. I bow down to that. But this is the authentic RTI information that I have placed on record before your lordships.
All right. An additional affidavit has been filed.
May I please, your lordship?
Yes.
My lord, in this case, I am appearing for the OP number 8.
Yes.
My order was challenged before this honorable court against the writ appeal.
Yes.
My lord, kindly see my counter affidavit, my lord. To writ appeal number 280 of 2012. I have filed the counter. Counter affidavit on behalf of the respondent number 8.
Yes.
Well, kindly see the page 23.
Yes.
Well, running page 22. In this application, a prayer is made to the modify or clarify the order dated 19/1/2010 to the extract of the opposite party number 5. While taking decision, appraise may not be influenced by any observation made by this court as regard infrastructure facilities. Before taking a decision of upgradation of the school, in the order quoted above, which was passed by this court on 19/1/2010, no observation whatsoever was made regarding the infrastructure facilities available in either of the schools. This court only remitted the matter back to the government. My lord, emphasize this line, my lord. This matter was back to the government to re-examine the matter afresh before taking a decision with regard to upgradation of either of these schools. While remitting the matter back, this court, by way of the guiding factor, recorded that the Chandannagar UGM school does not fulfill the infrastructure. There are two schools, my lord, Chandannagar and Koldia. Chandannagar school was upgraded by this authority, my lord. That order was challenged. This honorable court disposed of this matter with a remitted back to this matter to the authority. The video inquired to the matter. This school, Chandannagar school, was upgraded. That order was challenged before this honorable court. That order was quashed. Again, this matter was remitted to the government. Till today, they have no action. Till today, they have not taken. Then, my lord, the Chandannagar UGM school not fulfill all the eligibility criteria. That is, one is the infrastructure. The Chandannagar UGM school has no infrastructure. That is school, playground, and other benefits, my lord. There is no available. To fulfill the infrastructure requirement and cannot accommodate the students.
Who was opposite party number 6 in the writ petition? Who was opposite party number 6?
My lord, friend.
6. Opposite party number 6 was who?
School, my lord.
School. I see.
Director, secretary.
They are the school in which place?
My lords, now my lords, what has happened?
No. You are the school in Chandanagar.
Chandanagar and my lord Skuldia. There are two villages under the block of all.
No, the present appellant is who?
Chandanagar. Chandan.
Read appeal filed by the Chandanagar UG school.
Now they say that they are in a position to get upgraded.
And my lords, upgraded plus the site has also been decided by the
That order was passed.
No, my lords. There is some confusion.
With your lordship permission, may I clarify?
What is the status of the school?
I'll clarify your lordship.
Just. What is the status of the school now? It is upgraded
It is
now.
running by virtue of your lordship's interim order.
Okay.
Now, my lords, the Tehsildar has seen two sites. All of these things is on record before your lordships. Those two sites have been demarcated. The villagers from where my learned senior is appearing, the villagers have signed the petition. They say we have no objection in amalgamating the two schools, given that these two schools are being named before some late personalities. That was agreed. This resolution was prepared. It is only before the government may not implement that.
My lord and friend, give me the original affidavit just now. I have received. They have taken a stand. The collector was inquired this matter. Your lordship directed to the government. Who is the collector, my lord? I am posing a question to myself.
What are you saying?
My lord, kindly see my read application.
No, collector is government, sir.
And the factual background is that Chandanagar was already submerged in Vaitran river.
OP number 1 is the state of Orissa represented through its secretary in school and mass education.
The secretary have correct instructions. You have gone and agreed that there can be an amalgamation of the two schools.
Yes. No, my lord.
Yes. That's what this additional affidavit says.
My lord, kindly see this order.
Sir, order is earlier. Additional affidavit is filed in 2018.
My lord, just now I received this copy, my lord.
Very well, sir.
Read that copy. 2-3 pages. You can read it here only.
The 2019 affidavit, in fact.
So I pray lordship kindly. I have taken instruction. I pray lordship kindly taken up on after lunch. My lord, kindly see.
How many times? Nothing left. We'll vacate the stay anyway. We'll dispose of the writ appeal. We'll just make a note of whatever is said in the additional affidavit. That's it.
My lord, they have taken a stand. The school was amalgamation by the two schools. So I pray lordship kindly pass over.
This is
after lunch, my lord. First case, your lordship taken up first case in after lunch.
Considering the welfare of the student, teacher, and the villages, if the amalgamation has been done, then this is good for the students. Not the problem.
My lord, this school was no infrastructure.
Now it has
done. Now more school project is going on. It will take over. Don't worry.
My lord, so I pray lordship kindly taken up after lunch. I have taken instruction after lunch. I have no objection. I pray lordship kindly taken up after lunch.
Yeah. Now the infrastructure is done. Don't worry. All now this government schools are transformed now.
Well, there are two read applications before this honorable court.
No, don't fight here. Go there. Go around. You settle down.
So an additional affidavit has been filed, stating that in order to resolve the dispute between the two villages, that is Kuldiha and Chandanagar, a meeting was held on 1st August 2018 at the collectorate Kendrapada under the chairmanship of the collector, which was attended by villagers of both villages. Full stop. Both were asked to give their views on the name of the school, and has been unanimously decided the school be renamed as Government Gopabandhu Chandan Nagar Kuldiha UG High School. It stated that this name was approved by all the members present at the meeting.
That is not correct, my lord. My lord, I am appearing in the connected writ appeal. I am appearing on behalf of the villagers of Koldihi. They have never been called, my lord. They have never been called by the collector for an amalgamation.
So we can't go behind all this, sir. This is filed by the. This is filed by the.
My lord, I am in that writ appeal number 281.
Whatever it is, this is filed in 280.
Yes.
And this is filed by appellant number 2. This is Chandan Nagar Village Education Committee.
Minus.
So what is the state's stand?
Well, here what has happened, that Chandanagar village is already submerged in the river Vaitrani. That is why, my lord, this question of amalgamation came into picture, my lord. Thereafter, my lord, this is the order which my lord senior was reading that was passed in the first round of writ application. And in this writ application, my lord, the order which was impugned, that was subsequent writ application, wherein taking note of this submerging of that village, this direction was issued that both these schools may be amalgamated, because my lord, as per the policy of the government, only one school can be upgraded for high school in one gram panchayat. That is why, my lord, that direction was given that both these schools may be amalgamated and upgraded as per the government policy.
No, so according to you, this meeting did take place.
My lord, that I have to take instruction.
No, the additional affidavit, you don't have a copy of that?
Yes, I have that copy is with me, my lord.
So the annexure to the additional affidavit is your minutes only.
That copy is with me, my lord.
The minutes of the meeting, it's been forwarded to the Advocate General by the collector, Hendrapada. The minutes has your minutes.
This affidavit is with me, my lord. Whether that
My lords, all of these documents have been obtained by way of RTI. All of these documents that are placed before your lordships have been obtained by way of an RTI.
Earlier, the Tahsildar given a report. There is no school in the Chandan Nagar.
Correct. So that's what they will have a location, sir.
Two locations.
They're only
My lord,
renaming.
there are two locations. There are two locations, my lord.
No, the Tahsildar Oli, they call it Oli, is it? Was asked to finalize the location.
Yes.
So has he finalized the location?
Yes, my lord. It's there.
No, my lord, they are not.
It's there in
my law engineer.
You may see page 7 of my affidavit.
They have taken a stand. I am calling for all the villagers. We are the BC, we are the secretary. They have not, the collector never called to us.
Annexure 9, page 7.
So it's going to be in your village only, sir.
Yes, ma'am.
The school is going to be in your village.
My lord, there is a village education committee, my lord.
No, but you're not happy that there's a school in your village.
Yes, my lord. I am.
Then what is the problem? What is the problem?
My lord, there are two schools. There are disputed between the Chandan Nagar UGM school and Koldia school.
There is no school, sir, in Chandan Nagar.
There is no school in Chandan Nagar.
In a flood, he's just saying.
It is submerged in the Baitarani.
Entire village or the part of the village?
And a part of the village, substantial part of the village, and they have shifted to this
this place.
The question of amalgamation came into that in the impugned order. It is because of the stand taken by the government in the counter affidavit that the village does not exist anymore. That is why this question came up.
Yeah.
However, my lord,
How can you have objection to a school opening in your village?
In their village, your lordship, you see annexure 9 page.
My lord, I have no objection, but my lord, kindly see one report, my lord.
What is your problem? Tell us the problem. What is your problem in having a school in a village? The full-fledged, upgraded school is there. What is the problem?
Our school is also upgraded.
What is our school, their school? Sir, there's going to be only one school.
One school now, sir. What is the question of our school?
My lord, till today, there is two schools. There is only one school.
That's why it is merged and now
That's why it's going to merge.
One entity.
My lord, as per your lordship's interim order, the school is continuing.
What is the problem then? School is continuing.
It is going to merge with this Koldiha school. It's going to be renamed as Koldiha UG High School. Chandanagar Koldiha UG High School.
Yes,
My lord, I have no objection. My lord, kindly see, your lordship passed an order to incur the matter.
All right. The additional affidavit encloses minutes of the meeting held with both villagers, where the above decision is recorded. The report of the inquiry report of the Tahsildar dated 24th August 2018 is also enclosed. No, 31st August 2018 is also enclosed. Paragraph. Council appearing for the Koldiha villagers appears to have some reservations on the above decisions taken. So he under the impression that there are still two schools functioning, whereas council appearing for the Chandanagar school states that the school does not exist.
My lords, the school is continuing as on date by virtue of your lordship's interim order.
States the school is continuing as of date because of the interim order passed with this court. Otherwise, they have no objection to the amalgamation of the two schools at the new location. Paragraph, a direction is issued to the collector Kendrapada to hold a joint meeting, once again of both villages, and to place before the court the decisions taken at that joint meeting as regards the merger of the two schools, consistent with the decision already taken way back on 1st August 2018. The minutes of the meeting be enclosed with an affidavit to be filed by the collector before this court before the next date, with advance copies to consider the parties. List on 21st November.
Obliged. My lords,
The interim order to continue.
Obliged.
Yeah, after lunch.
Special weekly list past over matter item number 37.
Made with your lordships. My lord, the payment of just and fair compensation by grid corporation, by the Power Grid Corporation of India, that is opposite party number 2, is the core issue involved in this writ application, my lord. And what has happened? I have made twofold prayers, my lord. The first one is to declare the, laying of the, my lord, this transmission lines, my lord, over my, these are all tribal people, my lord. And transmission lines have been drawn by the Power Grid Corporation of India under section, my lord, 10 of the.
What is the problem with the transmission lines?
My lord?
What is the problem with transmission lines?
My lord, they have to pay for the user of the, this thing, my lord. For which, my lord, they have paid me compensation, which is very meager, my lord. For that, I have to approach the district judge under section 16(3), my lord. So I have to approach, my lord. So your lordship may kindly give that liberty. And
All right.
My
Concept the petitioner seeks to approach the '63 of the 2013 Act.
No, this is 12, my lord. 12, my
Which provision?
My lord?
You said under section 16 of which provision?
Not of the Indian Telegraph Act, man. Subsection 3 of section 16. My lord, 10 says 10 B and D.
I have filed one counter.
Yes, my lord. They are also saying that I have got an alternative remedy to approach. My lord?
Section.
My lord, the relevant provision is, my lord, section 10 and B and D of the Indian Telegraph Act.
Please read that provision.
May I read that provision? My lord. My lord, the 10 Indian Telegraph Act 1885, section 10 B. B speaks of that the central government shall not acquire any right other than that of the user only in the property. My lord.
Telegraph Act is for telephone lines, right?
No, my lord, your lordship has dealt with this matter, my lord, in case, my lord. I have got a, but that is against me. So that still, my lord, I have got
This is not an electric cable.
No, these are electric, my lord.
Huh?
Electric transmission lines.
Then?
That is covered under the Indian Telegraph Act, my lord. Indian Telegraph Act. May I just hand over one judgment delivered by your lordships, my lord?
Yes.
My lord. Do you have any copies, my lord? Your lordship has.
So the mobile tower must be. Yeah. BTS mobile. But here this is for 400 kV double circuit electric power transmission.
Power transmission lines, man. 400 kVA Raurkela Raigad, man. Over the agricultural fields of the petitioners. One of the cases dealt with by your lordship's panel, I have brought that judgment, where your lordship has said that section 10.
That's right. It also involves section 67, 68.
Yes,
and 164, the Electricity Act.
Yes, ma'am.
That's what I was wondering. It can't be only the Telegraph Act.
No, my lord, I stand corrected. So, my lord, for claiming compensation, my lord, the relevant provision is subsection 3 of section 16, my lord. If I am agreed by section 10, B and D. B and D speaks of user and D speaks of full compensation, my lord. That full compensation is, my lord, subject to, my lord, scrutiny by the district judge under section 3 of section 16. Adequacy of the compensation. Sufficiency of the compensation. There was challenge was made to the erection of the lines itself, my lord. But the payment of compensation and other things were not involved, excepting that your lordship has said that they have received the compensation. Here you have also received, but that is always subject to scrutiny by the district judge of the concerned district under subsection 3 of section 6.
So this 164 brings in 164, the Electricity Act brings in the Telegraph Act. The petitioner states that in view of section 164 of the Electricity Act, read with section 10 and 16 of the Indian Telegraph Act, the petitioners will approach the district magistrate.
District judge, my lord. Learned district judge Sundargarh, my lord.
Then district judge Sundargarh with an appropriate application for enhancement of compensation.
Very meager amounts have been
Here
paid,
it says
14,000,
judge.
16,000.
No, but just see 16.1.
16,1.
It says district magistrate. You have to go first to the district magistrate.
Like NHA. 16. District magistrate, we have gone, my lord. We have approached, my lord. Already annexed
And
6 series.
16.4.
Yes, my lord. Annex 6 series. Annexed 6 series, my lord.
If it didn't
We
dispute
have
arise.
represented to the learned district magistrate, my lord.
16.3 16.3
No, it's only for the proportions.
My lord.
See, 16.4 is similar to 30.
Yes, exactly, my lord. But 16.3 speaks of any concern sufficiency of the compensation, my lord. If any dispute
So
arises,
you'll approach under 16.3.
yes, madam.
Okay. We'll approach the district judge under section 16(3) of the Indian Telegraph Act 1885 for enhancement of compensation. So if such application is filed by the petitioners not later than 19 September 2022, it will be examined and by the district judge and disposed of in accordance with law as expeditiously as possible.
Pardon, my lord, I am from opposite part number 3. I had entered my appearance since 3rd December 2021. My name doesn't reflect there, man.
Oh, like indicate his name for opposite part in the all right.
Last matter, item 45.
In this case, Milords, petitioner has challenged Milords the constitutional validity of section 21A, clause 1 and 2. This case 1 and another matter which is not in today's list, Milords, in 2 also. Some other cases, Milords. And counter has been filed. In fact, this amendment is a sequel to a judgment which was there by your lordship in our favor in Visa Steel's case. There are 2 judgments earlier. Because I will kindly permit to file a rejoinder, Milords. And the other case, your lordship will tag this matter along with 25046 of 2014, Milords.
List along with petition civil 25046 of 2014
minors
on 22nd November. You say rejoinder were filed in the meanwhile. Both these matters, is it? This is the
In
2397.
the past case, suppose the NALCO may be permitted to file counter. Your lordship, that counter may be adopted. I will take instruction and if necessary.
I am appearing in the second matter, Milords. I am sorry.
Second matter, we have filed counter.
I am
in the first. Is anyone appearing in the first?
I am appearing in 6629 of 2013, Milords.
6629.
Imami paper.
In 22397, you say despite a passover, none appears. This is not possible. Because in the first one, even in the first call, nobody appeared.
Your lordship. Your lordship, in the second matter, we have already filed counter.
Yeah, second matter, we'll list along with that other matter
Minors.
for 22nd November.
Minors.
All right.
Obliged.
Weekly list fresh admission, item number 1.
May please, Lords. Here the petitioner is the ward member of the Gram Panchayat, Lamtapur Gram Panchayat
Pursuant to public notice issued for grant of IMFL on license, they have passed a resolution in the Gram Panchayat, and that was forwarded to the collector. After filing of the writ petition, the collector has taken a decision. But I have filed that, and it has been Lordship flag A is there. The decision of the collector
Rejected the on-shop application.
Yes, that they have rejected. Since there is violation of 27 is there, so now they have rejected the proposal.
Action no more.
In view of the rejection
in that light, Lordship may dispose of.
Yeah, in view of the rejection of the application of opposite party number 5 for grant of an IMFL on shop by the letter dated 12th July 2022 of the Excise Commissioner.
No, Collector Koraput has rejected.
Collector Koraput. The no cause of action survives as far as the present petition is concerned. It is disposed of.
Weekly list for orders item number 2.
Please, your lordship. My lords may look at order dated 10/3/2020. Your lordship had adjourned the matter awaiting the appearance of Mr. H.S. Misra.
Where is he? I saw him yesterday or Friday. He was here.
No, I'm appearing through BC mode, my lord.
Yes.
I'm appearing through BC mode.
All right, sir. All right.
My lords, here I am in custody, having surrendered in the court below on 30th of January 2013. This FIR was lodged on 16/1/2013, my lords, against unknown persons. Two dead bodies were found lying at the end of a bridge in the early morning hours of 16th of January, my lords, which led to the filing of the FIR, my lords, by a cousin of the deceased against unknown persons. Subsequently, my lords, the crime branch took up the investigation, and since the petitioner was implicated, the appellant number 1, he surrendered to custody on 30th of January 2013. Since then, he is in custody except for the periods on which he has been granted furlough and interim bail by this court, my lords, for his illness, my lords. The entire case of conspiracy against the appellant petitioner here, my lords, is based on no evidence whatsoever, my lords. And the only evidence, my lords, is the confession of the co-accused leading to recovery, my lords, which is not admissible so far as the present appellant is concerned, my lords. The prosecution story that the appellant along with others criminally conspired has not been proved in the trial through any evidence, my lords. The allegation that the petitioner's Xylo was used has been found that to be unsubstantiated in view of the forensic report, which shows that there was no incriminating material found in the Xylo. No one has seen the petitioner along with the other co-accused, my lords, either prior to the incident or at the time of incident, nor the deceased has been seen in company of the appellant. The allegation in the FIR was that the deceased had been called to attend a feast by one Lambodar Putel, who is not an accused in this case. And the entire case against this appellant is based on political rivalry, my lords, for which he is in custody since January 2013. The IO has also, it has been elicited from the IO that there are no criminal antecedents against this appellant. Although, my lords, so far as the deceased persons were concerned, from one of the deceased, my lords, a court summons was found, which shows that they had criminal antecedents. I am not linked either with the recovery or, my lords, with the last seen theory, nor, my lords, anybody has deposed about my being seen along with the other appellants.
And I'll invite your lordship's attention to the recent judgment of the apex court, my lords.
Yes.
Reported, that is Satyendra Kumar Antil, my lord, wherein their lordships have said that grant of bail in appeal is also an appeal is a facet of the trial. And at para 40 and 41, their lordships have said that prolonged incarceration, including delay in hearing of the appeal, amounts to violation of Article 21, my lords. That case where their lordships have said that it is high time that a separate legislation be
for grant of bails. Correct.
Paragraph 7, 40 and 41 are applicable to me.
Yes. What do you say, Mr. Katkia? We'll hear you, Mr. Mishra, in a minute. I'll just hear.
My lord, the present appellant for whom my lord and senior is placing his submission is plus the main accused. He has given the Hujali blows to both the deceased person, whether this is a case of double murder. And so far as
no, there's a case based on circumstantial evidence.
Circumstantial evidence. Circumstantial evidence. And one instruction I have received from the jail. This particular appellant is quite notorious and he's threatening inside the jail to all the jail officials.
Oh, I see. Where is that?
Yes, please.
No. Have you filed an affidavit here?
No, I have not filed the affidavit, but I can file the affidavit.
You file an affidavit because only Mr. Panda can meet it. Otherwise, it will simply be an allegation made orally.
That is Mr. Katkia's Miller's usual submission.
No, let him, therefore, we don't want to take it on its face value. Let him make good by putting it on affidavit.
He could have done so, Millers, in these 4 months, Millers. What made him sit quiet?
In many matters, my lord, it's taking time.
Who is taking time?
I'll file the affidavit.
All right. Mr. Katkia states that he would like to file an affidavit regarding the conduct of the appellant in jail. He will do so within 1 week. Within 1 week?
Yes.
All right. With an advance copy to Mr. Panda, who is permitted to file a response thereto before the next date. Copy of the affidavit also be served on Mr. S.S. Mishra and counsel for the appellant, for the informant.
May I make a small request, Millers?
Yes, please.
Your lordship may call for a report from the jail also.
Right.
Let a report be
I'm sure that report will be enclosed with the affidavit.
No, Millers. This is all Millers, Mr. Katkia's imagination. The lordship may call for a report.
All right. Independently, a report be called for from the superintendent of the concerned jail. All right. We'll list it on 11th August.
Weekly list item number 3.
My lord, this CM appeal has been filed for restoration of the.
What's the main matter about you tell us?
There is a PIL, my lord. There is the petitioner has brought to your lordship's knowledge. There is a pious institutions has been, that is the manipulation and also this is misappropriation of money, everything, my lord. Only pray for a judicial inquiry or an independent body. Any inquiry for independent body, my lord.
See, if there's corruption, you go to the Lokayukta.
Yes.
Is it a public institution?
Public institution, my lord. This is
then go to the Lokayukta.
That is college, my lord. And a next that is relevant para 6 and 7.
This
and representation also
Tapovan Higher Secondary School.
Higher secondary schools.
This is a government body.
That is a private, that is a non-government school, non-government higher secondary school.
If it's a non-government school, if it's a private school, how do you?
It is a aided school.
Getting granting aid.
My lord, getting granting aid, my lord. There is under that is 3B.
Okay.
Section 3B is come under this 3B of the.
But he's made a representation. Let them consider that first. All right. For the reason stated that CM APL is allowed, the order dated so and so is recalled, and the writ petition is restored to file. In the main writ petition, you say the petitioner is a representation, bracket annexure 4 series, What is that to show you have actually delivered this representation?
Representation only either opposite party number 1 or 2, my lord, your lordship.
No, what is that to show you have actually delivered it to them?
Yes, delivered, already delivered.
No,
What is that?
Proof?
Where the
Already
proof?
delivered, delivered.
Where is the proof?
Received about unfortunate.
No, then you make a fresh representation.
Yes,
there
sir.
is manufactured at the chamber.
My lord.
Permitting the petitioner to make a fresh representation to the authorities concerned and to follow up on that representation before seeking appropriate remedies, the petition is disposed of.
Wiki list item number 4.
My lord, your lordship may fix up a date for disposal.
No. You make the proper.
Item number 4, my lord. May I please, your lordship?
Yes.
The petitioners are villagers, my lord, challenging the lease granted by the Tahsildar opposite party number 4. Wearing the
Same thing, sir. The representation, is it delivered properly?
Yes, representation delivered. Your lordship, kindly see page 98.
7.
Kindly see page 98, the report of the superintendent engineer of the Anandpur Canal Division. Page
No. Your representation, sir.
Yes, delivered. My the receipt copy is there.
Is it 84?
No. What is that to show you delivered it? Page 90.
Page 53, my lord, received by the Tahsildar Gossipra, my lord. Page 53.
No, you've made non-stop representation, sir. Last one was 2022.
My lord, the
Annexure 9. Annexure 9.
And the representation given subsequently since the 2016, my lord.
Collector.
Forget 2016, you are coming to the court in 22.
Yes, my lord.
You have given a representation in April 22.
Yes, my lord.
What is that to show you have actually delivered it?
Is there any stamp from the office or any postage? I mean, your this proof.
Page 89, the same representation, my lord.
That's it. That 89 is that MLA signature on top.
Yes, my lord. That is correct.
That is not good enough for saying that it is received by the collector.
I'll file the.
All right. Counsel, the petitioner seeks leave to withdraw this petition with liberty to file a fresh representation to the authorities concerned. And after following up on such representation, to seek appropriate remedies in accordance with law. This post office withdrawn with liberty is paid for.
Wiki list item 5.
Item 5, my lord, may I please, your lords? My lord, I am in BC, my lord. Item 5, my lord.
Yes.
My lord, I have the petitioners of the villagers. They have filed representation, my lord, on 18/5/2022.
Where is that?
My lord, at Annexure 4 series.
What is that to show it is delivered?
My lord, your lordship may kindly come to the representation which is given to the collector that at its front, my lord, date has been mentioned 18/5.
What page?
My lord, 21.
It's 27, I think.
27, my lord, I'm sorry. 27.
That left whatever that scene. No, that is hardly that's not the stamp of the collector, sir.
My lord, no, my lord. It's not a stamp, but when this is a usual practice, my lord.
No. Sorry, sir. This is not the usual practice.
They put a stamp, receipt stamp in every office.
And there's a diary number also.
Diary number is there.
My lord, then I will file a fresh.
Counsel, the petitioner seeks same order. Leave to withdraw this petition, liberty to file a fresh representation.
My lord, that may be considered within a very short period.
No. You file it, sir.
My lord, tomorrow I will file, my lord.
Whatever, sir. After you file and if they don't do anything, then you can file a petition. Yes.
Wiki list item 6.
My lordship, I beg to take your leave to appear virtually. My lordship, this is a petition in the form of a PIL which seeks to bring to the attention of this honorable court the current issue of ragging, which has...
There are numerous defects pointed out in the petition.
My lordship, I admit there are numerous defects and I am ready to cure the...
Please cure them. The defects be cured within a week, list thereafter.
Wiki list item 7.
May I please, your lordship? First of all, I would like to draw your lordship's kind attention at page 29, Annexure 7. This is the policy decision in respect of excise for the current year, my lord. Lordship, kindly come to the relevant portion at page 33. Page 33, my lord. Clause number 4.2414. Clause number 3 says, my lord, no shop shall be allowed to be shifted before it starts functioning at its original location. Then clause number 4, a shop situated in rural area will be allowed to be shifted to another location in rural areas only. Similar principles shall be followed in case of urban areas and wards. Shifting shall be followed within the same excise station. Lordship, kindly come. The OP number 5, who has a license in respect of a Balisai IMFL shop in ward number 28 in Cuttack town, municipal area. He had never made his shop functional, my lord, from since the date of excise year 2021. Then he filed an application for shifting. Then on shifting, there is an inquiry, lordship, may say Annex 2. It starts from page 16. The operating page is page 17, last paragraph.
On what basis you are saying that that shop had never functioned?
Because the since the date of license issued in his favor, he had never opened or never lifted the MGQ.
Page 17, last paragraph.
Last time I see the last paragraph, page 17, the inquiry report by the Deputy Superintendent of Superintendent. He says, in view of the above facts, I am submitting my inquiry report with and view that since the new site is suitable for functioning of IMFL officer, that is Raja Bagija as Balisai shop is being settled now, but not functioning full till date. It means it was never opened, my lord.
No, that is not.
Then, my lord, Annex 4, page 19. This is the recommendation made by the collector. Also, in the last paragraph, page 20. I am enclosing here with an application or relevant documents in inquiry report of DSC in charge, Inspector Excise, Sadar Parents Cuttack, and soft copy of the public notice. It is required to place the proposal before the Government of Excise Department for necessary consideration for shifting of the shop to the new site for the remaining period of the year 2020-23, as the existing and new applied site comes under separate excise station. His shop was settled, my lord, in the excise of section 2. Now he wants to shift his shop to excise station 1. So in both the inquiry report clearly says there is a gross violation of policy of 4.214, 3 and 4. With this year, we file objection before the Commission, Learning Commission, that Annex 5 on 28/6/2022, without considering our grievance. Immediately by the Annex 6/27, the Learning Commission has transmitted the file to the government. So only why one life file is pending before the government. Government has no power to relax, as Lordship knows. In 26, only government has power to relax certain restrictions. But here the policy decision, government has no power. Only it has to consider, because the different excise station, different ward, that new just it is coming to new bus stand where it has been going to be started. That that proposal as well as our objection is pending before the government. Let government take a decision.
My lord, shifting of a shop from one excise station to another excise station, it's not a new case. My lord, friend must have come across several cases where relaxation has been made. And my instruction is that in the meanwhile, government has already relaxed it and granted the license by order dated 19/7/2022. Government has already decided, and
on 18th they have only filed.
19th they've done it. Mr. Mandri, learned AGA states on instructions that on 19 July 2022,
the proposal has been approved by the state government. The shifting proposal.
So there is a not incongruity to the policy decision
from Bali Shahi
by relaxing the decision, policy decision.
Yeah. Bali Shahi to what? Raj
Badambadi, Khan Nagar, no Badambadi.
Completely excise different station, my lord. Their own policy they have violated.
You must have filed several cases where excise stations are changed and shifting was allowed.
So I pray, my lord, let my Lawrence Senior supply a copy of that license, the approval order.
You get it under the RTI.
Enabling to take
you get it from RTI Act.
RTI Act, it will take another 1 month.
So what can it?
Bali Shahi to Raja Bagicha has been approved.
Yes, proposal has been approved.
Without considering our grievance.
How can you say that without considering? That is approved on by letter number 3374 dated 19th July 2022.
By letter dated 19th July 2022. In that view of the matter, no further directions are called for. The petition is disposed of. Right.
Weekly list item number 8.
Liberty to approach once again.
Obviously, sir, you don't need a liberty. You'll come back.
Next, and here also under section 27, the Panchayat and the Pali Sabha has passed resolutions, and it was
have entered through cavator.
Section 27 says about restriction of on grant of on license, Lord. Here it is a schedule area. The panchayat has passed resolution under Annexure 2 and Sarpanch has forwarded the resolution. Under Annexure 3, the Police have also passed resolution. The objectors also filed on Annexure 4. But Annexure 5, the government has now directed for inquiry and they have received some objection or favorable petition which cannot be considered under Rule 33(2) says if any objection or suggestion is received after the due date, it can be considered and summarily to be rejected. Lordship can like glance.
Here, so your objection was given when? What was the last date for objecting and when did you give?
Annexure 1. Last date is, my lord, objection is 16/3.
And you gave it on 14/7.
I have given the resolution is within 30 days.
No. When did you actually give the objection?
But I have given objection on 24/3. Resolution of the Gram Panchayat is 22nd and it was forwarded by the Sarpanch on 24/3.
So last date is 20th.
No, under the rule section 27, the notice period is 30 days. So within 30 days we have given the resolution and the Panchayat resolution.
Asked to consider it.
Both. That may be.
Now, your lordship may kindly have a glance on the impugned letter, Annexure 5.
Yes.
Annexure 5 is impugned. Last 2 lines, I will bring it to your lordship's kind attention. This is impugned and challenged. It is therefore requested to kindly inquire into the matter and furnish a detailed report to this department for taking a decision at this end. This
I am challenging on the ground that Rule 33 to lordship kindly have glance. I am challenging this letter of the government.
Government has directed the Excise Commission to inquire. And inquiry is being conducted. So it is premature. Let the inquiry report come.
33(2) says it cannot be considered and summarily to be rejected.
Any objection or accept the
inquiry is being conducted, sir.
And I have instruction that inquiry is going to be conducted.
The resolutions may be considered along with that also. How can they consider their objection or application?
How can you anticipate that they will not entertain your objection? How can you?
From this order it shows.
No.
From this order of the government, it shows that the resolution has not been considered.
Rather, this order is in your favor.
How?
Government has directed for inquiry. During the course of inquiry, everything will be taken into account.
33 says any objection or suggestion received after the said period shall be summarily to be rejected. Shall be summarily to be rejected.
After the period.
Yes, period. The objection which you have received by the government, that is after the beyond date. Because government date is 12/7. Annexure 5 is dated 12/7.
Anyway, we'll record a submission that they are going to consider objection.
Yes.
Already
asked for an inquiry. During the course of inquiry, all objections will be considered.
Resolution of the Gram Panchayat, not objection, Lord. It is a resolution passed by the
objection.
That is an objection. Resolution is in shape of objection.
Mr. D.
But Annexure 2 and 3, 4. 2 to 4 may be considered.
Additional government advocate states that by the letter dated 12 July 2022, the government has already ordered an inquiry under Annexure 5. So he states that in the course of the inquiry, the objections of the villagers as expressed in the Palli Sabha resolution dated 24th March 2022 bracket Annexure 3, as well as the
2 and 3. Both. 2 is the Panchayat and 3 is the Palli Sabha.
Resolution of separate Panchayat, Gram Panchayat, bracket Annexure 2 will be considered. And a decision will be taken after considering those objections as well.
Your lordship may direct that he may produce this order to the excise superintendent.
Yes. I'll let that be ordered.
I understand that the inquiry is going on.
So now inquiry is going on, my lord. Notices have been issued to all objectors, my lord.
Yes, Lord. Lordship has said that after giving opportunity to all parties.
And the applicant, my lord, OP number 5.
Giving opportunity to all parties, it may be decided.
Yeah, the decision will be taken, obviously. But the inquiry is an inquiry, no?
This is inquiry. I will participate, no?
That's right.
Also, Lordship said that
in the inquiry, all the parties, including the objectors, will be heard.
Also, Lordship may direct
the inquiry be expeditiously concluded,
including the
period of 2 months from today.
Yes. And Lord and brother is saying that is the Gram Sabha resolution. That is a monthly resolution. Let him produce at the time of inquiry.
Yes.
That is a monthly.
That he will produce.
All objectors.
Pursuant to public notice, this resolution has been passed.
Weekly list, item number 9. 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 Weekly list, item num
May I please, Rashimaj? This is a read petition in the nature of public interest litigation, my lord, with the villagers object.
Cleared all the defects.
Sorry, my lord.
One must be not serving on the state. This representation has it been delivered?
Yes, my lord.
Some postal receipt is there. Okay. The petitioner's representation dated 10 June 2022 shall be examined by the Tahsildar.
Video.
The BDO.
I have removed all the
By the
BDO.
Block Development Officer Basudevpur, and after giving the petitioners a hearing, a reasoned order shall be passed thereon, not later than.
You have also written to collector also.
Yes, sir.
Collector, video, everybody.
19 September 2022. And we communicate to the petitioners within a week thereafter. The court clarifies it is not expressed anywhere in the matter. Petitioners.
Obliged.
Item 10.
10 is the illegalities committed in the selection of beneficiaries under the Pradhan Mantri Awas Yojana, my lord.
But
Go to the Lokayukt, sir.
Defects we have removed.
No, let him go to the
1
Lokayukt.
and 4 as the SR not removed. Defect.
4, 6
not
rupees.
paid, 6 rupees deficit.
Subject to the petitioner curing the defects,
In course of the liability.
including the court fee, within 2 days. The petitioners, anyway, have to go to the Lokayukt. The petitioners permitted to. Yeah. Approach the Lokayukt in accordance with law. The petition is disposed of.
Obliged.
But you pay the court fee. You can't go like
In
that.
course of the I am submitting. my lord.
Yes.
In course of-
Weekly list for admission, item 11.
It may please your lordship.
Yeah.
I'm giving a small
11,
date.
your lordship. I am there in the opposite party, and also the
Yes.
collector writ petition is also filed by me.
All right.
Mr. Mohanty had taken the time from the other occasion to file a rejoinder. Has he filed a rejoinder? I don't know. No copy has
No,
been
rejoinder is not filed.
not filed now.
Rejoinder, my lord, no. I have not.
Taken time to
No,
file.
not necessary, my lord.
All right.
It's all right. But last time he took a time, that's why I made a mention, your lordship.
Yes, please.
Your lordship, in that event,
My
can
lord,
it be
that,
taken up next week, your lordship, because I had to prepare a brief note with regard to both the writ petitions. and
The award is very much clear, my lord. The direction was made in the award to regularize our service as sweeper. And from 1/4/92, I have filed this writ petition praying for that no back wages has been granted from 1/4/92. I have prayed for granting me back wages from 1/4/1992, from the date of regularization of my service. The Mr. Mishra challenged the award on regularization of service, my lord, against the regularization of service. You lords may kindly see the award, para 15. Small award, my lord. From 14, para 14 and 15, your lords kindly see. At page 60 of my writ petition. It is no doubt true that a casual employee or daily wager not selected as per the requirement rules has not got no right to claim regularization. It is equally true that the hands of the tribunal are tight to pass any order directing regularization of any such workers. But if the standing order of an industry contains a provision for regularization of such workers, in my opinion, the same would prevail all over. The standing order of the management, a portion of which has been marked as Exhibit 26, shows that the classification of different workers. According to it, a casual workman means a workman who has been engaged for work which is intermittent or sporadic or of casual nature, not extending beyond the maximum period of 3 months at a time. The evidence of the management witness shows that the above-named 3 disputants were appointed as casual worker for a period of 9 days with effect from 1/4/92, and they were terminated on 30th July 1992. This shows that they were not terminated after 90 days, but were allowed to continue beyond 90 days. The full text of the standing order has, of course, not been filed by the either party so as to enable the court to examine the real status of the casual worker. But the letter of the Central Mines Planning and Design Institute Limited, Exhibit W, indicates that persons engaged as casual workers for more than 90 days acquire a right to claim regularization. It is that even while the three workmen were working as casual employees, the management had moved its higher authority for further extension of the term of the three workmen beyond 90 days. It is also recorded that after sanction of some permanent posts of sweepers, an advertisement was made asking the local employment authority to sponsor the name of the suitable candidates, and at the same time, the three disputants were asked to get their names sponsored through employment exchange. The said recruitment exemption would not, of course, be held due to recruitment ban imposed by the Code India Authority, but nonetheless, the correspondence of management shows that it was equally interested to provide regular services to these three workmen. The most vital and disquieting aspect of the case as appearing from the evidence is that though the three workmen were given appointment as casual employee for a period of 9 days with effect from 1/4/1992, they have been terminated in the month of July 1992, that is much after 90 days, without further extension. This itself makes the workmen, three in number, entitled to claim regulation as per the standing order of the management. Para 15. It was argued by the management that the 90 days contractual engagement of the above disputants not being in accordance with the recruitment procedure, they were not entitled for regulation. Be it noted here that when the management has allowed these workers to continue as casual employees, for whatever reason it may be, beyond the contractual period of 90 days, they cannot be denied regularization in violation of the standing order. The tribunal, no doubt, is capsized with its power to direct regulation, but a direction to the management to regulate the disputants, namely Gokul, Purna, and Madhav, would not be bad in the face of the statutory protective clause given under the standing order. But insofar as the case of the fourth disputant, Sri Ganesh Chandra Naik, is concerned, except in the thin line of evidence of the union that he was also working continuously like others, there is not a scrap of paper to show that, like the others, three, he was also given a contractual appointment as a casual workers for a period of 9 days and above. Therefore, in these circumstances, he is declared not entitled for any relief. Thus, to sum up, the management is directed to regularize the services of workmen Gokul, Purna, and Madhav in accordance with its standing order within 6 months from the date of receipt of the order subject to the reservation norms. They would, of course, not be entitled for any back wages and other benefits except.
So, what does the standing order say? Where is the standing order?
Says, my dear, Exhibit 26, that if a casual employee continue more than 90 days, is entitled to be regularized from service.
Which is that page?
Pardon me?
Which page is that standing order?
That is in Exhibit 6, my lord. In the record, there is. In the writ petition, I have not annexed, my lord.
So that's the main document. Otherwise, where's
I filed the copy of the standing order by way of an affidavit. You will also keep it next week. I will file that. They have also it. Standing order is with them, my lord. Also, there is a tripartite agreement also there. Both is to be filed.
Temporary.
Pardon, it is not with me. I will call for that, my lord, and file by an affidavit. Or you will also direct the management also to file.
42.
42.
Standing order.
That has been marked as Exhibit 26.
No. The standing order.
Before the tribunal.
Find out where the standing order.
Yes.
He says he'll file it with an affidavit.
Yes. 1 week time only.
Mr. Mishra, do you have the standing order?
My lords, if it is referring to Annexure 5 in my writ petition, your lordship sees.
No, just you have the standing order with you.
That is a part of my writ petition, your lordship.
The next one.
The next
Second one, your lordship.
Second.
Annexure 5.
Annexure 5. Yes.
Just read that.
Yes, he leads to possibly page 43, your lordship.
Right.
3.4.
Yes.
3.4.
Yes, a casual workman means a workman who has been engaged for work which is intermittent or sporadic or of casual nature, not extending beyond a maximum period of 3 months at a time, provided that for employment of casual wagon loaders, the time limit of 3 months shall not apply. This is not my submission will be that this is not applicable to him, Your Worship.
Says, if no positive order is issued by the management on the expiry of the provisional period or extent of the provisional period, as the case may be, the employee's consent shall be deemed to have been confirmed. But this is 6 months again, 6 months.
6 months. No, but it doesn't talk of contractual appointment or casual appointment. Right? Here it's provisional appointment. That's different.
It's a provisional.
And to fill a vacancy. So it's advertised and
yeah.
So these provisions, where do they guarantee that if you work for 90 days, you'll be regularized?
Well, I'll find out the standing order, my lord. I'll go
No, his writ petition. You have his writ petition.
It may not be standing orders in respect of central mine planning and design, my lord.
Yes.
They are only, they refer to the, what is the definition of casual workersman. Casual workman definition 3.4, my lord.
No, definition is one thing. See, there should be a provision which says a casual worker who has put in 90 days of work.
More than 90 days.
No, will be regularized. Where is that? This doesn't say that.
I'll find out, my lord, that's actual.
That's the main basis of the whole case, isn't it?
Yes. My lord, main basis, they were engaged in 1986 continuously, my lord.
No. The finding is you work for 90 days.
More than 90 days.
But what is that more than? See, the question really is there must be a provision which says if you work more than 90 days, you are entitled for regularization. Where is that?
Maximum 3 days, 3 months.
No, that is casual. That you can work only as casual for 3 months maximum. Not that you'll get regularized if you work beyond 3 months.
That I will examine your lordship. Grant me 1 week time. I will find out all them. I will find out them.
The entire award proceeds on the basis as if
of the standing order, my lord.
Exactly.
They have also taken into aspect, my lord, that since 86 they have been engaged. One aspect.
Then
they created permanent post.
They are only going by standing orders.
The standing order, I will find out, my lord, the standing order. What is the standing?
But you have the second companion writ petition? The second one.
Yes,
second one, I have.
That you turn to page 41,
that they say that is the standing order.
43.
They refer to 3.4. A casual workman.
No, they also refer to 3.6.
3.6. Probationer, that is probation.
Correct. So it doesn't apply to you. That's what he's trying to make is all this doesn't apply to you.
3.6 is not apply. They said this standing order is not applied to me, my lord. It's not
because you're So because you're a casual worker, you could have gone maximum for 3 months.
Yes.
Beyond 3 months, if you work, you're not even a casual worker.
Yes.
How do you say that you have a right for regularization under the standing order?
Somebody as a casual worker works more than 90 days, my lord.
What is the status?
This is not
ceases to be a casual worker.
This is not the complete standing order. I will find out the complete standing order.
Monthly learned counsel appearing for the petitioner in writ petition civil 12676 of 2007 states that he will place on record the relevant portions of the standing orders, which according to him support the case of the petition.
Next, one chapter, just one chapter.
No. 22nd September.
Yes. Weekly list item number 12.
My lord, in item number 12, I may be permitted to file a compliance affidavit, my lord. Your lordship. And the PO Baleswar is also present, my lord. Your lordship direction has been substantially complied with, except that payment of revised So far as that revised pension part is concerned, my lord, that authority, letter of authority has already been issued by the Comptroller of Accounts to the Treasury, my lord. Within a week, my lord, it will be disbursed. Except that all other entitlements has already been disbursed, my lord.
My lord, the copy is given to me just before the recess. Let me check and it will come some other day.
Counsel for the state assures the court that except has handed over a compliance affidavit where it is stated that there is substantial compliance with the directions issued by the court.
Except that payment of revised pension part.
As regards payment of revised pension, he states that the necessary
authority of letter of authority has already been issued to the Treasury by the Comptroller of Accounts.
The compliance will be effected positively within a week from today. Counsel, the petitioner seeks that.
My lord?
No, he's just handed over, he's just filing it.
Well, I am filing here only, that may kindly be accepted.
Counsel for the
My lord, this is just
petitioner
now.
states that he has to seek
It is
instruction.
thought on me. Let it some other day. I will check.
Copy
whether
I have
it is
given. I have given the copy.
Compliance with correct or not. And one more thing, my lord, the differential gratuity, service retirement gratuity. There is no mention.
No, that has also been disbursed. That letter of
you check up, sir. You check up.
My lord, that personal appearance may be dispensed with. Personal appearance may kindly be dispensed with.
September.
26th September.
May I pray, my lord, personal appearance may kindly be dispensed.
The personal appearance of
DEO Baleshwar, my lord.
DEO Baleshwar is dispensed with. For the
Obliged.
moment. Yeah.
Weekly list item 13.
May I please, my lord, I am appearing on VC, my lord.
Yes.
Here, the petitioner was a landless agriculture laborer. In 1973, lease of 1 acre of land was granted to him. And till date, he is in possession thereof. But in 1987, after 14 years, the land ADM, Additional District Magistrate, exercised its sumoto jurisdiction under Section 7A.
No, what is your locus? Where is the lease with which you... This was after notice to you or not?
Yes, after notice, after filing of so cause. And after the 25 years of the impugned order, writ petition is filed. 25 years.
Oh, what's the reason for the delay in filing the writ petition, sir?
Delay is that he
My lord,
has explained.
not 25 years, my lord. My submission is that the petitioner is a poor and illiterate person. He could, though he appeared and filed his objection, he could not know.
Not for 25 years, sir, please. Not for 25 years.
Not 25 years, my lord. Not 25 years.
When did he come to know?
My lord, in 2012, my lord.
That's the year of filing, sir. The order is 87.
My lord.
You came to know only 25 years later.
1987. My lord, I came to know only on 2012, my lord.
No. This was passed after hearing you. Where's the question of coming to know only then?
My lord, because the order is completely without jurisdiction. It has been
No. You participated. You filed a statement. So cause. Then it was Then the order was passed.
That everything was in your knowledge.
Yes.
After 12 years,
The impugned order dated 19th August 1987 has been passed by the Additional District Magistrate Bhubaneswar in RC case number 491. 1987. So admittedly, the said order was passed after hearing the present petitioner and after he filed a show cause paragraph. The petitioner has no valid explanation why he waited for 25 years to file the present writ petition challenging the said order. Full stop. Counsel, the petitioner states that the petitioner is poor and illiterate and was not aware of the said order till 2012. The court is not prepared to accept the above explanation. The order was passed way back, the impugned order was passed way back on 19th August 1987 after the full participation of the petitioner in the proceedings. Full stop. In the circumstances, he cannot claim to be unaware of the order passed in the said proceedings. Not being satisfied with the explanation for the inordinate delay in laches in approaching the court, the petition is dismissed.
Weekly list item 14.
In compliance of
Item
order
number-
dated 5/7/2022, today I'm filing the supplementary affidavit indicating the payments that the area salary as well as all pensioner benefit that has been released in favor of the petitioner. And all those
An
released.
affidavit has been filed by the opposite party in compliance with the order dated 5th July 2022.
Paragraph 4 and 5.
In paras 4 and 5, the details of the payments made to the petitioner as per entitlements have been given. These payments were released way back on 5th August and 20th December 2013. In that view, the matter, no further directions are called for. The petition is disposed of.
Lost my grand liberty if any cause of action survives.
No. They all happened in 2013 itself. Yes.
Weekly list item 15.
In the case of public interest litigation, wherein the petitioners have challenged the illegal encroachment of village land. And encroachment case 1 of 2012-13 was initiated against the opposite party on 3, the encroacher. Till date, no action has been taken. And several times they have taken.
Yes,
for demolition or
the original writ petition was filed challenging inaction of the authority. We have filed counter affidavit that encroachment cases have already been filed. These counter
No, he says the encroachment case, we had adjourned it to say what is the status of the encroachment case. He says those encroachment cases are allowed and they've asked to be removed and yet they continue the process. Premises.
My lord may direct that if within a particular time-bound manner.
What is your regular times you have taken for submitting status report?
Have you filed your status report?
My lord, actually, last
Neither
Mr. Das was
it has been demolished, nor a status report is being filed.
1 minute. It is there, my lord. Just a minute.
What is the status?
We have not received the
The
status.
grievance of the petitioner is that despite the encroachment case having been disposed of and the opposite party number 5 being directed to be removed, no action has been taken by the petitioners till date. Already time was granted on 7 July 2022 to the state government to inform the court of the current status. Mr. Monti seeks and is granted the last opportunity to do so by the next year. September.
Weekly list item 16.
May I please, my lord?
Yes.
My lord, the IR number 9890 may kindly be directed to be tagged, my lord. That is for amendment, my lord. 9890.
9890.
Today morning I have filed, my lord. I don't think it fit to file here, my lord. Today morning I have filed.
9890.
An advance copy.
No, copy.
Yes, my lord, I will serve.
This from 26 September.
Weekly list item 17.
Obliged.
Just now, I rejoined the affidavit. I take instructions. Item 17.
Sorry, not 7, 9 now.
Weekly list item 18.
18. Sub item number 1. बोलो उधर से लिया May I just give one suggestion? let them pay some amount and the CIT appeal will dispose of the appeal within 4 months. All the
Here,
three cases.
this issue is squarely covered by your lordship's decision in Delhi High Court in this, I filed it LG Electronics versus PC, where your lordships have clearly held that the office memorandum dated 31st July 2017, which directs 20% deposit for stay, that cannot fetter the discretion of the assessing officer. I have filed it, it's on record. And subsequently, it has also been confirmed by the Honorable Apex Court that also I have filed that judgment. It's on the board of your lordship. I think your lordship's mic is off.
In view of the order dated 8th August 2017, in writ petition civil 6778 of 2017, bracket, LG Electronics India Private Limited versus Principal Commissioner of Income Tax, of the Delhi High Court, which has been affirmed by the Supreme Court by the order dated 20 July 2018 in Civil Appeal 6850 2018, bracket, Principal Commissioner of Income Tax versus LG Electronics India Private Limited. The impugned orders of the CIT in the present cases are set aside, and the matter is remanded to the CIT A or CIT.
Yeah, appeal is pending. Let the appeal be heard.
No.
Only stay.
Principal CIT.
Principal CIT.
Same
Sorry.
matter.
To the principal CIT 1 for a fresh decision without insisting on a minimum 20% deposit.
My lord, I have a very serious question in my case at para 21. Now, this is also national faceless appeal. Now, when the link came and it was to be recorded, and now very curiously, my lord, one lady was conducting the hearing. And when I said, Madam, please turn the pages, she said, I am not allowed to ask any question or give you, please keep saying, I am only a staff. So hearing has been conducted by a staff. And that link was to be recorded and given to me. They have not given, and they have admitted this statement in the counter. So this is a complete, the assessing officer must be somewhere else.
Yeah.
The staff is recording. This is a gross misconduct, your lordship. Let them produce that recording before your lordship. Some heads must roll in this thing.
I know. We'll wait for another case. This, go back to the CIT. The CIT will, after hearing the petitioners, the principal CIT will, after hearing the petitioners, pass fresh orders.
And only one leave. Let them supply me the copy of that recording. I'll use it because that is there. They have admitted they will supply me at page 43. That was to be supplied to me, never supplied. At page 43 of my writ petition, my lord,
that is on a main matter. This is only the 20% matter. This is only a 20% matter. Let's not mix up that. Not later than, we'll have to pass fresh orders not later than
December 20.
No, not the appeal, sir. This interim order. Not later than 12th September 2022. The petitions are disposed of in the above.
Notice may be issued, my lord.
Yeah, after hearing you have said so.
An expeditious disposal of
appeal also.
Subject to the above orders, the main appeals before the CIT A also be disposed of expeditiously and in any event not later than 15 December 2022.
The entire orders will become nullity in so many cases if this has happened. I was shocked that lady asking you, please submit. I have not.
This is going to be the beauty of AI.
All three cases, my lord.
All three cases, correct.
Weekly list item 19.
It's 1 week time to file counter activity.
Liberty, counsel for the opposite party department prays for and is granted 4 weeks time to file reply. Interim order to continue. List
I'll rejoin the rapid group there.
Yes, list on. Please. 23rd November.
Thank you.
Weekly list item 20.
May I please, Manoj?
Yeah.
This case, Manoj, I filed an additional affidavit, Manoj. Your Lordship may kindly take up my additional affidavit, Manoj. Here the challenge was in 148 notice, Manoj, issued by the Income Tax Department, Manoj.
I will stop that copy to him.
Manoj, I've served a copy on my learned senior, Mr. Chiminka, Manoj. Your Lordship may straight away come to page 13, that's Annexure 2. The reasons for which, after the Honorable Supreme Court's order dated 4/5/2022, on 6/5/2022, they give me the reasons. And if your Lordship may turn over the page and permit me to place the penultimate paragraph, Manoj, at page 14. Your Lordship got it?
Yes.
In view of the above facts, I have reasons to believe that the SSE has failed to disclose its income truly and fully for this year, as its income of 15 lakhs from undisclosed source.
So it's 15 lakhs and below, then it's.
After that, my lords, your Lordship may have annexed the CBDT circular. That's at Annexure 15. The Annexure 3 at page 15, dated 11th of May 2022. And if your Lordship would straight away come to page 17.
Yes.
7.1.
Correct. They will drop the proceedings.
And this assessment is for the year 13-14 in my present case, my lords.
Yeah.
So this CBDT circular for 13-14, 14-15, and 15-16, they say that if the income escaping assessment in that case for that year amounts to or is likely to amount to less than 50 lakhs, then, my lords, they have to abandon this 148 notices, my lords.
No, let him appear before the assessing.
No, why should I appear?
If it is less than 15 lakhs, can go straight away.
Yes, it is true. Let him appear before.
Why should he appear, sir?
Your CBDT.
Have your own room.
You have enough work. Your officers have enough work.
With this faceless assessment scheme, my lords, are compelling us to do many things, my lords, for which they are not permissible, my lords. So I've challenged the 148 notice, that is at Annexure 1 at page.
An additional affidavit has been filed by the petitioner, enclosing the reasons provided to the petitioner by the department for reopening the assessment for the year 2013-14. These reasons show that the reopening of the assessment was on the basis that, open quotation, the SSE has failed to disclose its income truly and fully for this year, as its income of rupees 15 lakhs from undisclosed source has been passed through accommodation entry, thereby escaping income to the said extent in terms of Section 147 of the IT Act for the said assessment year, unquote. It is pointed out that by the recent circular dated 11th May 2022, issued by the ITJ section, CBDT, Department of Revenue, Ministry of Finance, where the income escaping assessment is less than rupees 50 lakhs. 50 lakhs. Notices need not be issued. Notices
cannot be issued.
Cannot be issued in terms of para 7.1 of the said circular. In that view of the matter, the impugned notice,
Annexure 1 at page 14,
bracket Annexure 1, and all proceedings consequent thereto, and orders and demands are hereby quashed.
And the Annexure 2, Miller, the reasons also has to go.
Sorry?
Miller, Annexure 1 and 2. 1, 2 of the additional affidavit.
Yeah, 2 is a consequence of 1. Isn't it? Yeah, and all orders consequent thereto. Yeah.
Greatly obliged.
All right.
Item 21.
21, my lord, it stands covered by your lordship's judgment, my lords. Dated 7/11/2022, my lords. May I just pass on that order, my lords? After Ashish Agarwal's case, my lords, your lordship have been kind enough to pass it. Here, my lord, even though the notice is dated 31st of March 2021, in fact, I received it on 1/4/2021, my lords. So, my humble submission would be it will be covered by your lordship's judgment. I mean, order pursuant to your Honorable Supreme Court's order, my lords.
All right.
Archie, kindly have a glance, Lord. He has only stated that he has received the notice after
there has been
1/4, but there is no scrap of document that he has received after that. Your lordship see the annexure.
But I've specifically stated
only stated
that even though there's no
literally same, Lord.
there's no
Very same date has been received. Lordship see, signed date is 7:30 p.m.
But there's no counter file, my lord.
And subsequently, Lord, has proceed further. Your lordship see 142(1) has already been issued. Now we come before lordship saying only scrap of document how is received. Can he document? Then your lordship can be.
But tell me one thing. This is additional CIT.
No, that is within their limit, within 4 years. No, that is not beyond 4 years. If within 4 years, no, they have the power to issue notice.
No, that is my second submission, lords.
No, second submission, not you.
If it is joint commissioner, because what I, Lord, to cut the matter short, now since there was no counter affidavit to my specific stand, that even though it is dated 31st of March 2021, I received this on 1/4/2021. That is after coming in of the new act. And your lordship's order following the Honorable Supreme Court's order will cover me. And I don't think, Lord, my learned friend will have any objection to this.
No,
because you can issue a fresh notice.
Sorry?
You can issue a fresh notice.
No, but one, it is a old act, Lord.
No. In this order, you have said
they are in that case, Lord, I correctly remember they have received. They show the document and the mail that they have received after 31st March.
Look,
here is a case, he has only stated that I have received on 1/4. There is no scrap of document.
My instructions, my instructions now, my lord, is I have now received a notice on 148AB.
Yes.
So once it is a 148AB notice, obviously it is after 1/4/2021.
Then so I have to file a counter.
Let my learned friend file a counter. I'll file an additional affidavit.
All right. Reply we filed within 4 weeks. Rejoined of the next date. Interim order to continue.
Yes.
22nd November.
22nd November?
Yeah.
Yes.
Obligement.
Wiki list item 22.
My lord, I am appearing virtually, your lordship.
Yes.
My lord, by the impugned order, my lord, it is passed under the newly inserted section 148A under clause D, my lord.
Yes.
Clause D says that after the show cause notice, considering the reply, an order has to be passed by the sitting authority that it is a fit case for issuing notice under section 148.
Correct.
That much only. The jurisdiction is very limited to that extent. Thereafter, notice will be issued, and thereafter 147 proceeding will be carried out. In this case, my lord, he issued a show cause notice. I filed a reply. Thereafter, while deciding whether it is a fit case or not for proceeding under 147, 148, he has entered a final finding, your lordship. Yes, and finally adjudicated a dispute. Kindly turn to my lord, page 47. Page 47, para 6.2. My lord, may I read, lordship?
Yes.
On analysis of the income tax return filed by Kasera Agency Private Limited, it is found that the company has shown total income of for the year 16-17, 17-18, 18-19 is rupees 2,48,357 and 995.95 respectively. Hence, it is clear. That the concerned company has now no creditworthiness to provide unsecured loan to the beneficiaries, including the HSE. The my lord shall kindly come to para 6.3 bottom thereafter. The HSE failed to furnish the detail of creditworthiness and source of investment made by Kasera Agencies Private Limited during 17-18. Since the HSE is a beneficiary and received 22,50,000 as bogus unsecured loan from 17-18 from Kolkata-based paper sale company Kasera Agency Private Limited, hence 22,50,000 will be fixed taxed in the hands of HSE as unexplained cash credit under section 68 of the Act for the financial year 17-18 relevant to assessment year 18-19. My lord, kindly have the section, my lord, page 14. What section reads, my lord? Section 14. Page 14, my lord.
Page
14, 1-4, my lord. I have quoted the section there, my lord.
Yes.
Page 1-4, my lord. Section 148A. The assessing officer shall, before issuing any notice under section 148A, conduct an inquiry, if required, with the prior approval of the specified authority with respect to the information which suggests that the income chargeable to tax has escaped assessment. Then B, provide an opportunity of being heard to the assessee with the prior approval of the specified authority by serving upon him a notice to show cause within such time as may be specified in the notice, not being less than 7 days, but not exceeding 30 days from the date on which such notice issued, or such time as may be extended by him on the basis of an application in this behalf as to why a notice under section 148 should not be issued on the basis of information which suggests that income chargeable to tax has escaped assessment in his case for the relevant assessment year, and results of inquiry conducted, if any, as per clause A. Then C, my lord, consider the reply of the assessee furnished, if any, in response to the so-called notice referred to in clause B. Then D, under which the impugned order is passed, decide on the basis of material available on record, including the reply of the assessee, whether or not it is a
No,
fit
but
case.
what is your problem?
My lord, in the impugned order, he has entered a final finding of fact. He is
Not
advocating
final.
his-
Come on, please. This is not final findings, sir.
My lord, kindly
It's not
see.
a final finding. This is only a 148 notice. That's it.
My lord,
This is only a decision on your reply to 148 AB. You can clarify that this will not be treated as a final opinion. That's the end of the matter.
that may be done, lordship.
All
Because
right.
that is
The only grievance of the
issue.
petitioner at this stage is that when passing an order in response to the petitioner's reply to the notice under section 148, capital A, small b of the Income Tax Act 1961 bracket Act, the assessing officer has rendered a single quotes final unquote view that the income that the income of the petitioner that a certain income of the petitioner has escaped assessment. Full stop. Having perused the interim order, the impugned order, sorry, the court is of the view that the observations therein of the assessing officer to the above extent will not be treated as single quotes final or single quotes conclusive, and a fresh decision would be taken on the petitioner's response to the notice to be issued to it under section 148 of the Act. The petition is disposed of. Right.
Oblige, my lord.
Wicked list item 23.
Obliged, my lord. My appearance for the
My lords, item 23, that's I'm appearing through VC, my lords. That's pursuant to my lord's last order dated 5th of July.
Right.
My lords, I have filed a detailed counter affidavit detailing the steps that the state has taken with regard to countering the.
Don't call it popular incidents. These incidents are never popular, sir. Most prominent must be.
My lords, I didn't say popular, my lords.
Popular. First line is popular incidents. These are not popular.
My lords, is reading my counter affidavit, is it?
Oh, your counter affidavit. Oh, I see. This is the note, is it? Oh, so sorry.
Plus my counter affidavit, my lords, I have filed it on 16th of July 2022.
Divided the counter into two parts, my lord. First, they have narrated about the enforcement of the provision of Wildlife Protection Act 1972, and the second, my lord, they have mentioned about the preventive and countermeasures taken against illegal elephant poaching and protection of elephants, my lord. But they have not mentioned, my lord, why they are unable to protect the elephants, my lord, from illegal poaching, my lord. And for the kind information.
You're not audible, sir.
Am I audible, my lord? My lord, besides their unable. Am I audible, my lord?
Now you are.
Yes, my lord. And besides, they're unable to control this illegal poaching, my lord. And for the kind information, my lord, the special task force, which is constituted by the government of Orissa, they have yesterday they have found, my lord, in Sambalpur division, my lord, the burnt elephant bones, my lord.
My lords, if I may take my lords through the counter affidavit, my lords, just to my lords impress upon the court as to what steps have been taken.
That is already narrated.
This is on poaching, so it's a big problem. There is a, so I asked him to draw a map. So it's this zone. So this para 22, Mr. Monty.
Yes, my lord.
Actually, this is a standard statement. This is neither here nor there. All out efforts are being done with involvement of all stakeholders to curb the incidents. This doesn't give us any idea of what actually has happened.
Lords,
For each incident, no, let me just ask you. For every incident of poaching in the last 1 year, do you have a listing out of those incidents? In your affidavit, in your counter affidavit, do you have you listed out each of those incidents?
May kindly turn to page 10 of my counter affidavit, para 15, my lords.
Yes.
During the last 5 years, from 2017 to 2022, 14 cases of poaching of wild elephants have been authorities.
1 year.
No, not 14, sir. There's much more. There's much more.
1 year, it must be more in 1
Let me tell you, just this 1 year, from August 10th, 2021, there have been 6 incidents. And this is only up to 21st June. If you start taking July, there is already an incident in July.
My lords, there are 2 aspects to it. My lords, one is...
No, first we'll come to all the aspects one by one. You first tell me, have you listed out each incident of poaching in the last 3 years?
The listing out, my lords, in that detail, my lords...
Unless you acknowledge, first of all, you must acknowledge that there have been so many incidents of poaching, otherwise you'll be in denial. You simply say there are some 10 incidents, 5 incidents.
The incidents that have been reported, my lords, those are the incidents that I've put in, my lords.
Where have you put that? Where have you put that? Let us see.
Every day.
Where have you put that?
Newspaper.
Where have you put that?
My lords, page 15 that I was...
That para 15 is not a listing out of the incidents, please.
That's not the listing out. That is not the listing out.
Please listen carefully. We want you to list out every incident of poaching that has happened in the last 3 years. We want you to tell us what you did vis-a-vis each of those incidents. Did you catch hold of the culprit? Did you register a case? Have you registered an FIR? For every incident of poaching, have you registered an FIR?
Yes, my lords, with regard to the 15...
Have you arrested people? Have you prosecuted them? Have you convicted them?
My lords, with regard to the 15 incidents at least that is there, my lords may go to the second line in this regard.
Your statistics also not clear, Mr. Mohanty. Your statistics also, I mean,
11 cases have been booked, of which 5 cases are at trial. It's not, that tells me nothing. What is this cases booked means? What happened to the people whom you have arrested? Have you arrested or you simply booked cases?
No, my lords, the conviction hasn't happened, my lords.
No, please. If you not even apprehended the accused, how will the matter proceed?
50 persons involved.
You don't tell us. You tell us of 11 cases booked, 5 have gone to trial. What happened to the remaining 6?
Well, the other 9 cases, my lords, are under investigation.
What is that under investigation? For how many years? Under what stage? This is absolutely vague. This is how you get away by not doing what you should be doing. And if your measures in the last 5 years have proved ineffective, what have you done to strengthen your systems?
Whereas with regard to steps that have been taken to strengthen the system, there is a specialized wildlife cell millets that has been created under the aegis of the.
Your cell creation is not going to help. You have to just in the field what you have done, that is more important. Your cell creation, that is not going to help anybody.
Then if your cell has been effective, you should be able to tell us the incidence of poaching has come down. Then you do a comparison of how many incidents were there 5 years ago, 3 years ago, 2 years ago, and this year. Then we'll know that your cell is working.
Because I'll file an additional affidavit detailing the specific incidents and what is the stage of investigation and how many people have been arrested. Millers may give me 2 weeks time. I'll bring out all these.
No, actually, we want you to list out the incidents. Let's be very clear on this.
Yes, Millers. We
want you to formally acknowledge that there have been these many incidents of poaching. Yes. For each incident, these are the FIRs registered in these police stations. These are the persons accused who have been arrested, who are still absconding. Which are the cases you have filed charge sheet? Which are the cases that have gone to trial? If in 5 years you don't even have one conviction, there's something seriously wrong.
As I understand it.
The counter affidavit has been filed by the conservator of forests wildlife, working in the auspice of the principal chief conservator of forests wildlife, Orissa, in compliance with the order dated 5th July 2022, which broadly talks of steps taken for enforcement of the provisions of the Wildlife Protection Act. You have the Wildlife Protection Act. In Orissa generally. And in the second part of the affidavit, talking of the preventive and countermeasures taken against illegal elephant poaching and protection of elephants. In response to a specific query about on whether the Forest Department has actually listed out the number of incidents of illegal poaching of elephants, Mr. Ishwar Mohanty, learned ASC, drew attention to para 15 of the counter affidavit, which reads as under. Just take 26 and 27, bottom of 26, top of 27. The court finds the above paragraph to be vague in its particulars. Full stop. The court directs the principal chief conservator of forests (wildlife) to himself file an affidavit in which he will provide details of each of the instances of illegal poaching of elephants in the last 5 years, including the place of the region where the incident took place, the actual action taken, that is in form of registering an FIR, arresting the accused person, listing out the accused suspect oblique accused persons, arresting the accused persons, filing of the charge sheet with the details of the court where the case is pending, the details of the trial, the status of the trial, and whether there have been any convictions in any of those cases. Full stop. Two, if, as was pointed out by Mr. Mohanty, a special task force has been set up, the details of the, you have the notification of the special task force.
Have you filed the notification?
Wildlife crime cell. You've set up a wildlife crime cell.
Wildlife crime cell, page 29.
What has that done?
Because that is the cell that investigates into these.
No, you say Mr. Mohanty drew attention to an order dated 16th October 2015 of the Forest and Environment Department, Government of Orissa, constituting a single court's wildlife crime cell. Created in the CID crime branch. Full stop. The present composition of such wildlife crime cell will be indicated in the additional affidavit to be filed. And whether, since its creation, the actual number of cases it has itself investigated, which has resulted in a trial and conviction of the offenders. Full stop. So you have given a status report on some cases, just come to page 51 of your counter. Page 222.
Please, Millards, this is the case that was referred to in the petition with regard to the Athagad poaching case, Millards, where Millards committee was set up, and thereafter there has been an investigation into it, and about 10 people have been 10 people are suspects, out of which 5 have been arrested, Millards.
But that was in February 2022. We're in July.
Case number 1, Millards.
That's what that happened in February 2022.
Yes, Millards. Millards, may come to the last page, Millards, 44, Millards, page 44, internal page 44. Millards. Constitution of special investigation team to probe cases of recovery of body parts of elephants in Athagad Forest Division, SIT under supervision of Chief Conservator of Forest, State Wildlife Headquarters under the chairmanship of Regional Chief Conservator of Forest Anugod, including Conservator of Forest from State Wildlife Headquarters, and 1 officer from the STF of Orissa Police have been constituted by government with a number so and so dated 16/6/2022 and 27/6/2022.
Where are you reading, sir?
Millards, this is internal page 44, Millards, of my counter affidavit.
60. Oh.
44 minutes.
Last page of the counter.
What happened to that wildlife crime cell and all that?
Whereas the wildlife crime cell is the nodal agency, my lords, under which, my lords, all these cases are
But
prosecuted.
that nodal agency, you have any statistics of that nodal agency?
How many cases it's investigated and all that?
I will provide that in the additional affidavit that I'll file. my lords.
Should you not come up with a pattern? Because all of these are ODs. The persons whom you are arresting.
Yes, my lords.
So if it is all happening within the state, then how come you don't detect a pattern in this?
Who are mostly, I think that few people who are regularly arrested, that's a gang. So you could have easily.
If I may, my lords, with regard to only the Athagad case, because my lords, at least that is what is on record.
For
my
other
lords.
cases also, the same people would be there.
No, my lords, my lords, please bear with me. My lords.
No, the elephant trackers are themselves the accused.
Yes, my lords, and in fact, my lords, there has been action taken against them as well.
No, the persons you are arresting are all elephant trackers.
There are some people from the department, my lords, which unfortunately have been involved in this. And my lords,
Have you suspended them?
No, they arrested. They're supposed to have arrested them. The same people you're mentioning in all the cases.
departmental action has been taken.
No, in every encroachment, poaching case, you're mentioning the same kind of people. This is a bit strange.
No, well, my lords may see the annexure, my lords, which is E by.
Yes, I'm reading in detail that very annexure only.
Yes, my lords, and this is, my lords, the 5 cases which have been.
That's right. In each of the cases, have you studied them carefully?
Yes, my lords. Yes, my lords.
The same persons are there everywhere. How can it be?
Same Behra, Pradhan.
There's something seriously wrong. In every case, it can't be the same. If you've arrested people in one case, then how come they're still out and arresting them again in another case?
Well, I'll have to take instruction as to whether.
You have to first study it. You study it, you find out which are the common names in all these cases. Then you can ask them.
Or you have just created by copy paste. No.
It's a bit strange. Everyone you're putting in bracket elephant tracker. The person you're arresting are elephant trackers. Same.
Prabhakar Kumar.
Akula. Yeah, everywhere. Everywhere is Biranchi Behra, Braja Behra.
The letter officer.
All right. The affidavit be filed within 2 weeks. Yeah. The deponent will also remain present in virtual mode to answer the queries of the court. List on. August 16th. One is there. Manual scavenging. There are hardly any days left. 8th August.
And Mr. Mahanti, you read your file properly.
Yes,
Read
Malad.
it in every aspect of that and analyze it and come so that you can answer our query.
Milas, I must say, Milas, that annexure E by 1, Milas, that is
Every entire whatever you have filed and what is the
slightly
position of the petitioner, everything you should read it properly.
I'll definitely look into it.
Item 24.
Published, Malad.
May I please announce? Item 24. Lord, item number 24. I'm appearing for open number 5, 6, and 7. I need 4 weeks time to file counter. I've appeared for 5 and 7. I'll be appearing for 6. 4 weeks time may be granted to file counter.
And there also you want time. I have to 7.
5, 6, and 7.
Counsel appearing for MCL.
Yes.
Bracket opposite parties 5 to 7. Seeks and is granted 4 weeks to file a reply. The other also have to file a reply. The state.
Government, nothing to say because I am relying on the 2006 policy issued by the government. That is why the government is the party. For the impugned notice at page 41, Annex 3 has been issued by the MCL, my lord, which is contrary to 2006 policy, my lord. RR policy 2006.
The opposite parties 1 to 4 will also file the replies by the same date. Rejoinder for the next date. 28th November.
My miscase was liable. I have made a prayer that the operation of Annexure 3 may be stayed, my lord.
No.
Or any action, my lordship may clarify any action taken pursuant to that annex, because by virtue of that notification, so many people are going to be deprived. That is why I say any action, my lord, will be guided by the final result of the writ application.
We won't say anything right now. Let the replies come. Right.
Weekly list item 25.
Lord, item number 25, both the items may be tagged with WPC 13241 of 2022, which is posted to 19th
of September.
Or we tag list on 19th September along with
WPC 13241 of 2022.
Okay. 13241 of 2022. Over.
Also, permitted to file on written note of argument plus additional written note of argument.
All right.